It's a writ petition which is due to, if it could be taken up, because, my lord, a part of the building has already collapsed, my lord. The municipal corporation has proceeded to declare as a dangerous building. But the difficulty is, my lord, there are some inhabitants inside the building. Well, there was a previous writ petition filed when the court ordered, the division bench also ordered for the Kolkata Municipal Corporation to take steps to remove the inhabitants in light of the condition of the building. No steps have been taken. We have communicated with the authorities. They have not taken steps for 6 years. Now, my lord, in last 2 weeks back, on 30th of April, my lord, a part of the building has collapsed.
So what is to be done?
My lord, the entire building will go unless, my lord, we take steps for the purpose of demolition. We have received a notice under 11.4, but they have not done anything thereafter, my lord.
Come back after the vacation. We will see what is to be done. Within these 3 days, nothing can be done.
My lord, I have already filed the writ petition. My lord,
Let it be remain in the list. Non-prosecution. Give.
Appellate side matter. Kachari Rani Rashmani Kachari Bari, second floor, completely ruinous. Municipality
What
authority.
do you want?
Because your lordship's directed, find out the portion and then take steps. They decided they issued notice. Now, due to lack of coordination with the WBSCDCL, this demolition is not being caused. But it's serious condition. The rainy season is coming. That's the situation.
So what is to be done now?
Or kindly pass it necessary direction upon the authorities so that they can effect it.
After the vacation, we'll
Because
sit and pass
because
order.
we are
After the vacation.
oh,
Yes.
great. But may I file
File it in the department.
My lord, I am seeking leave to move a matter. My lord, I have served an advance copy upon Mr. Banerjee, my lord. I have a G+5-storied building and a sanction plan for the entire thing. Without even giving a notice on 27th of April, HMC people come and say that we are going to demolish the 2 floors, my lord. We write to the commissioner, my lord. Then the police authorities has come yesterday by stating that this week they will cause demolition. No notice, nothing. I have a sanction plan on record. I have served notice upon Mr.
The 5th floor sanction is there.
Till this 5th floor, my lord.
Very good.
I have talked to them.
Yes, speak.
There is an administrative problem.
Very well. Let him file. We will see. You take
My lord,
instructions.
may I come back tomorrow, my lord?
Sanction is there.
Day after tomorrow. Day after tomorrow. What is the error?
My lord, instead of teacher, the word teacher, that will be employed.
Give.
May I have my lord's leave to move a matter, my lord? I would be praying for an interim order. Baharampur municipality has passed an order under section 17A upon the owners. The owners contended that I am not responsible. The Baharampur municipality itself is responsible. They passed an order. We were taking steps to challenge that order. Firstly, it's without jurisdiction. Secondly, the provision under section 17A has not been notified. Now, what the threat is, what the purpose of moving this writ petition is that, my lord, we want an interim protection, because what they are doing, they would be passing an order, taking over the control and management of the entire water body.
Water body.
Water body. There's a water body, big water body, 132 kata water body, just bank opposite to the Baharampur municipality.
Who are you?
I am the owner.
Owner of the entire water body?
Entire water body.
Yes.
I have challenged that order because I have a document I will show. That's not my saying only. There's a
Is
document.
the number there?
Yes, it's numbered. It's WP number 12129.
Where is the item?
It's not appearing. We have filed it yesterday. We have served them tomorrow itself, my lord. Kindly allow me, my lord. There are 3 days, my lord. Any time yesterday, my lord will kindly.
Day after tomorrow.
Day
Give
after.
the number. Further notice to be given.
I will give. I will, certain.
Hopefully there is no private respondent.
No private respondent.
But ensure the presence of the municipality. Somebody appears for Baharampur municipality. I cannot remember the name exactly. You inquire and come back. Give notice also.
I will give a notice to the Baharampur municipality. Today it's by mail as well as by hand. I will send someone. Great.
Yes, call the list, please. Original, sir. Original.
I appear for the petitioner, my lord. This is my contempt application for the inaction of the police authorities not stopping the construction, lordship. Today, it is a 2-storied building which is standing there. When we filed the contempt application, it was 1-storied. By the time we filed and it has come up before your lordship, it is now two-storied. Lordship, I've got both the photographs. Lordship, the police are mere spectators. Even if we say that there is construction going on, lordship, there's no steps are taken.
The corporation.
This is appearing for the first time
For the
possibly.
first time.
And if any
My
Municipal
friend accepts
authority-
the notice, lordship, I
on
will-
behalf of the municipal respondents, if
It's a contempt petition.
Yes.
Will copy be served upon
Yes.
you
for the corporation respondents.
for the corporation? The petitioner alleges violation of the direction passed in the order dated 6th June 2022. Stop. Copy of the contempt application is yet to be served upon the alleged contemnor. Contemnors. Stop. Mr. Ronojit Chatterjee, learned advocate, submits that the copy of the contempt application be served upon him because he has instructions to enter appearance on behalf of the alleged contemnors. Stop. Next.
I'm serving a copy right now. 1, 2, and
A copy of the contempt application has been served upon Mr. Chatterjee in court today. Stop. Let instructions be taken. Stop. The matter is made returnable on.
lordship, content number 4 has to be served, my lord. There's a state that direction may be given.
Returnable on 12th June 2023. Stop. Let copy of the contempt application be served upon the alleged contemnor number 4, the officer in charge, Amma Street Police Station. Stop. The court video order dated 6th June 2022 directed the respondent authorities to take steps to deal with the unauthorized construction. Stop. Next. The officer in charge of the Amma Street Police Station was directed to keep strict vigil to ensure that construction is not made in the premises till a decision is taken by the corporation in this regard. Stop. Paragraph. Specific contention of the petitioner is that despite order passed by the court, the persons responsible are continuing with the construction work at a very fast pace. Stop. Allegation is that neither the police nor the engineers of the corporation are taking any steps to prevent such unauthorized construction. Stop. Next. Paragraph. The officer in charge, Amma Street Police Station, is directed to ensure that no construction takes place at the subject premises. Stop. Come back on the 12th. Let us see what can be done.
Your report may be filed, my lord, on the next.
Mr. Chatterjee is there. He'll definitely take instructions.
Great.
Let I beg to appear on behalf of the petitioner, my lord. Let pursuant to your lordship's last order, my lord, I have been served with the report which has been filed by the assistant engineer, my lord. দাদা, একটা copy দেবেন?
Last occasion, my lord, I have filed a report.
Page. The report dated 29th of April, 2023, issued by the assistant engineer. Well, for the first time on that day, well, it came to a notice that a review order has been passed by the special officer building as regards to the demolition proceeding. Well, now, well, I'll take your lordship to two documents. Well, first is the resolution which is annexed. It is not paginated. So kindly takes the page which is signed by the mayor. It's not in the writ petition. It's in the instruction which the report has been filed by them.
Signed by the,
Mayor.
yes.
Kindly see, they say that in terms of the regulation dated 2015, the order of the special officer building in connection with the demolition proceeding under such and such is as detailed in the agenda note is taken up for consideration. Now, without even giving a reasoning in the second line, they say that the following order of the SOB in connection with demolition proceeding under section 401 and 416 of the KMC Act 1980 may be placed for review. Your lordship was of the opinion that whether the mayor in council has that power or not. Now, I will be relying on the 2015 regulation before your lordship, which clearly says that the power of the review is only vested upon the commissioner.
Tell me one thing. By way of review, what has been done?
My lord, yes. Let kindly takes up the last page of the report. That is the last review order. Kindly see the nature of unauthorized construction remains the same, and the change of usable area also remains the same with
Which portion? Is
My
it
lord,
the special officer's order, 18th of April 2023?
my lord, date of hearing is 15/3/2023.
Yes.
Kindly see the same thing remains in the first page, my lord, before the ordering part. Area of unauthorized construction 97.736 square meter, and change of use area is 45.63 square meter. And now kindly takes up the first report, which is in the writ petition, which I have annexed, my lord, which says the same. There is nothing that more unauthorized construction has been made or something of that sort, my lord. That order is also in your lordship's report, my lord, which is the first page, my lord, after the report, my lord, first page.
977364566.
Same, my lord.
Yes.
Only because it has been remanded back. So, my lord, now they have come up with saying that yes, you have to change the nature. This portion will be regularized and this portion will not be regularized. Now, my lord, I am challenging the basic, my lord, whether the power of review is vested. I have gone through your lordship's judgment, my lord, that is on a separate context. Now, my lord, kindly, if your lordship takes up the 2015 regulation, my lord, once, whether the MIC at all has the power or not.
We will hear it after the
My lord,
vacation.
the difficulty is, my lord, I will be pressing for an interim order, because today, if this order of the special officer building is placed before the MIC and they accept it, my lord, my entire writ petition become infructuous.
So as of now,
My lord, only
it
this
is
much.
not yet finalized.
My lord, once the SOB has passed an order,
Yes.
then, my lord, it has to go to the municipal commissioner as per 408, my lord. Now, my lord, my basic thing is that whether that review is at all permissible in law, my lord. So today, my lord, if this order is at all being given an effect, my entire thing goes, my lord.
That is not the subject matter of the writ petition, my lord.
Maybe because, my lord, I was unaware of the thing. And your lordship directed them to bring on record. My lord, kindly, my lord, for my satisfaction, kindly, my lord, takes up the regulation once, my lord.
1 minute, the last portion, let me understand what the special officer has done. Total area of analysis, converted to office at the ground floor. I converted to flat floor. Tell me one thing. This went back to the special officer
My lord.
because of the
Because
order
of
of
no
the
reasons
mayor.
were given, my lord. Kindly see the mayor in council, mayor's order, my lord.
8th
May
of
be placed for
February
review.
23.
My lord, this is the resolution, my lord, 8th of February 2020.
Yes.
Just one line, may be placed for review. No explanation as to why, my lord. My lord, kindly takes up the regulation once, my lord, for my satisfaction, my lord. My lord, kindly sees the part, my lord, which starts with review of the order. if the municipal commissioner so thinks that the process of hearing was not followed properly, he may pass further order after review, recall the earlier order. So, my lord, here the case is that the municipal commissioner has already affirmed the order of the special officer building, and thereafter,
Where is that?
yes, my lord. But that is in your lordship's, that is in the report, my lord, kindly takes up the third page. It is also in the writ petition.
Yes, third page,
Lord, it is an order dated 30th of September 2021.
right?
Kindly comes to the, my lord, the ordering part.
Huh?
In view of the above, I am of the observed that already special officers building has passed an order dated such and such in respect of construction beyond sanction done by the petitioner at premises number such and such. And there is no bar from any court order for proceeding against the order of the special officer building by passing the same before the Board of Administration for approval. Hence, it is ordered that the matter to be processed by the PG building to put up the MIC agenda item before the Board of Administrator for taking decision within upcoming BOS meeting. With this order, matter stands disordered. So, my lord, it is affirmed. So, my lord, I satisfy the provisions of the regulation which says that only the mayor, only the commissioner has the power to review.
Where is that provision where from the mayor it is to go to the mayor in council?
My lord, it is not, it is a mayor in council. It's a department with signature of the mayor, because mayor is the signing officer.
No, after 30th of September 2021, the municipal commissioner records that the matter be processed by the DG to put up the MIC agenda before the Board of Administrators, right?
I will presume that 8/2/2023 is that thing, because it was put up before them. Because I have no knowledge, it is their internal communications which is being taken place.
No, where is the sanction of law that after the municipal commissioner, it is to go up
It's
to
not-
the,
That is what the honorable court has decided. A coordinate bench has said it is mere a stamping authority and on concurrence approval is required. It is not mandatory, manner, and rely on the judgment of a coordinate bench. Where the same issue has fallen, it has been said that, no, it is not. My learned friend was there. Only the difference was that
Oh, that is in respectable or different aspect.
the different aspect,
I'll hear you, Mr. Panda.
well, it kindly comes to straight away like paragraph 28 onward. Again, it's a harmonious reading of the third proviso to section 401 of the said act and clauses 3, 4, and 5 of the said regulation, my lord, which I have handed. Persuades the court that either the municipal corporation, the commissioner, or the officer delegated by him to hear a demolition case has the power to pass an order of regulation of minor deviation on certain terms and conditions and on payment of such fees as may be prescribed by regulation. Before such order is passed, the condition laid down under serial A2 of clause 4 would have to be taken into consideration. Condition A2 of clause 4 provides certain checks and balance for determination of minor deviation and regularization thereof. Calculation of the retention fee was to be made in terms of the rates prescribed in the budget schedule by the concerned department. Now, let kindly skips to paragraph and takes up page paragraph 30. Thus, neither the statute nor the said regulation authorize the mayor or the mayor in council to determine the minor deviation or regularize the same by permitting retention thereof. What deviation would be considered to be minor in terms of the said regulation, and what whether such deviation would be regularized upon taking note of the municipal commissioner, taking note of the condition 8(2) of clause 4 of the said regulation were solely within the domain of the municipal commissioner or the officer delegated by him to discharge his function in this regard. Before the this part is a bit different because here the challenge was as regards to the computation of the retention. Now, I will also take your lordship to paragraph number 34, 35, and 36. Paragraph number 34. In this case too, the decision of the special officer building stood good as there was no disapproval. Well, the disapproval is of the municipal commissioner. Here, well, the same case, the municipal commissioner has also approved. The said regulation also does not provide that the order would not take effect before the concurrence or approval was given by the mayor or mayor in council. This is not a case where permission was required. The said regulation is also silent about the consequence in case the mayor or mayor in council did not approve the decision of the special officer building.
only the municipal commissioner has the power to review the order as per the state regulation. Thus, the grant of approval of concurrence was a mere formality in the nature of ratification of the decision of the special officer. So, with greatest of respect, the regulation clearly empowers only the municipal commissioner to call for a review, and nowhere else. And nobody in the corporation has that power. It is only a mere body will give concurrence. And when kindly see your lordship, if it again sees the resolution, well, no decision given as to why the same was remanded. Assembly respectful submission for a stay of the order dated 18th of April. Without jurisdiction valid and the
Stay of
the special officer building subsequent order. It will not be there in the date because it was handed over.
why don't you file a supplementary? You have all the documents now. Or
My application is ready, I can bring it on board after the elections. So till that time, kindly if they restrain themselves not to give this.
Mr. Panda.
Now the learned friend they raise this question, that is not the subject matter of the writ petition. Pursuant to lordship direction, I file a report. And the report says, subsequently, the order of the special officer building has been reviewed, and in terms of the pursuant to lordship direction, earlier writ petition, the commissioner has taken a hearing, and that matter has been relegated to the board of administration to review of this matter. And after that, the special officer building has passed an order, and that has not been approved by the mayor in council. It has been sent to the mayor in before the mayor for approval. Now my learned friend has the question the validity of the my lord review. Well, let them file a fresh writ petition challenging that. What is the prayer of the writ petition and what now he has praying before the lordship?
But then the cause of action has changed substantially with the filing of the report.
My lord.
Certain documents have come in which were not to the knowledge of the petitioner. 15th of March 2023 hearing was taken. Did you give notice to the?
Yes, my lord. Kindly see. He participated.
Participated with objection.
And I will take a better ruling the special officer cannot stand by your lordship's judgment. He said that even the person responsible complainant has also to be heard. In the initial case, the complainant was heard. In this case, the complainant was also not heard. So I will take that one to my advantage. Finally, takes up the notice which is at page 38 of your lordship's. Sorry, 30 of your lordship's that was given to me.
The court merely directed or permitted filing of a representation, and that is to be considered. The court did not pass any order for review, isn't it?
No, absolutely not, my lord. But the commissioner has, my lord, think fit the matter to be sent for review.
The commissioner could have reviewed it himself. Why did he send it to? Why did the commissioner send it to the mayor in council, board of administrators? Where is the authority in law?
Well, that is not the subject matter in the writ petition.
Now the subject has come up by filing of the report.
That
please come. From the report. No, from the documents filed by the learned advocate representing the Kolkata Municipal Corporation, it appears that if that an order was passed by the special officer within bracket building on 18th April 2023. Stop. The order is presently pending approval before the mayor and council. Stop. Next. The petitioner was not aware of the said order passed by the special officer building on 18th April 2023. Stop. The petitioner has challenged the order of review passed by the municipal commissioner. No, not the municipal commissioner, passed by the mayor.
Yes. Yes, yes.
The petitioner is no, the petitioner challenges the authority of the mayor in directing review of the order passed by the municipal commissioner on 30th of September 2021. Stop. The jurisdiction of the mayor in passing the order of review, not in passing, in placing the matter for review has been challenged. Stop. Next. The petitioner prays for stay of the operation of the order passed by the special officer within bracket building on 18th April 2023. Stop. The petitioner, the learned advocate representing the Kolkata Municipal Corporation opposes the prayer of the petitioner. It has been submitted that the order dated 18th April 2023 is a fresh cause of action which cannot be decided in the present writ petition. Stop. The decision of the mayor in placing the matter for review is not under challenge. Stop. The same cannot be challenged in the present writ petition. Stop. Next. As it appears that the order of the mayor and the subsequent order of the special officer building is a continuation of the order passed by the municipal commissioner on 30th September 2021. Which the petitioner seeks implementation of. Accordingly, there may not be requirement of filing fresh writ petition. Stop. Leave is granted to the learned advocate of the petitioner to file supplementary affidavit annexing documents which was received by him after filing of the writ petition. Stop. Let the supplementary affidavit be prepared and served upon the learned advocate representing the Kolkata Municipal Corporation by Friday
By Friday.
or 1 week after vacation.
Not by Friday. Also.
By 19th of May. Stop. Next. The corporation will be entitled to file an opposition to the writ petition and the supplementary affidavit within a fortnight after reopening of the court after the ensuing summer vacation. The matter shall be placed for hearing in the combined monthly list of July 2023. Stop. Affidavit in reply may be filed in the meantime. Stop. Next. As it appears that The documents of the case are presently pending approval before the mayor and council, comma. The order, if any passed by the mayor and council, shall not be given effect to till 31st August 2021 or until further order, whichever is earlier.
July, August.
But for corporation also.
Why is your prayer incomplete? Prayer B, page 12, second line. What will be the date?
My lord, the document is annexed, my lord.
October 2009.
30th, 30.
Page 92.
2019, 9.
My lord, a report to that effect is here also. Also, can you see the report also?
Let me hear what the petitioner has to say.
My lord, initially, my lord, we have obtained a sanctioned building plan. Subsequently, my lord, there was certain deviations, my lord, we applied before the authority, my lord. The same was regularized and revised building plan.
Is your microphone working?
The revised building plan, my
Yes.
lord, the revised building plan has been sanctioned by the authority.
Yes.
Huh? Ulano.
Thereafter?
My lord, thereafter, my lord, the building has been completed, my lord, and the completion plan has been handed over. Now, my lord, what has happened, my lord, when the completion plan was handed over, the completion plan was given in respect of the initial building plan and not the revised building plan. So, my lord, my innocuous prayer before the authority was that if there is any mistake, my lord, kindly allow me, permit me, whether that mistake is on my side, then I will rectify. If it is on their side, my lord, let them take steps, my lord. Your lordship was of the opinion directing them to file a report as to the steps taken. But
Erroneous. Nothing. Subsequently, আগেরটার মতন হয়ে that is otherwise mistake.
Please come.
My lord, the technical, my lord, defect would be, my lord, rectified, that we have said. A report we have given.
The petitioner submits that construction was made in accordance with the plan sanctioned by the Kolkata Municipal Corporation. Stop. As there were certain deviations, comma, the petitioner applied for regularization of the same. Stop. The prayer of the petitioner stood allowed and the corporation regularized the portions which were were constructed in deviation of the original sanction plan. Stop. After regularization, the corporation issued a completion plan. Stop. The petitioner contends that there are certain errors in the said plan and the deviations which were subsequently regularized were not indicated in the completion plan. Stop. The petitioner applied for correction of the error in the completion plan. Stop. The application of the petitioner not being considered by the authority, comma, the present writ petition has been filed. Stop. A report has been filed by the learned advocate representing the Kolkata Municipal Corporation signed by the sub-assistant engineer within brackets civil, assistant engineer within brackets civil, and executive engineer within brackets civil, building department, Borough 10, on 13th May 2023. Stop. The same mentions that the case records and the site was inspected. Stop. It appears that a building plan for construction of G+4 storied residential building with abutting road of width 8.760 meter over total area of land measuring 377.833 square meter as per deed was sanctioned in respect of the premises number 24/1A, Rajpur Mondal Para Road,
Raipur, Lordship.
That's Raipur.
Raipur Mondal Para Road, ward number 99, on 30th October 2009. Stop. During construction, the person responsible made some deviations which were subsequently regularized. Stop. Completion plan of G+4 storied residential building was issued on 29th December 2011. Stop. Paragraph. After checking relevant records, the corporation detected that due to inadvertence, certain errors cropped up in the completion plan. Stop. These said errors will be rectified under the suitable subsection of the KMC Act 1980, read with the KMC Building Rules 2009. Stop. Next. From the instruction provided by the engineers of the Kolkata Municipal Corporation, it appears that the engineers have admitted that error has cropped up in the completion plan that was issued. Stop. The errors are rectifiable and are required to be rectified. Stop. Next. In view of the above, the instant writ petition is disposed of by directing the
Executive Engineer, Lordship, Civil Building Department.
he will be the appropriate authority.
Yes.
Respondent number 4, madam.
That's one of four.
The respondent number 4 being the executive engineer, building department, Borough 10, to take immediate necessary steps for rectification of the errors in the completion plan issued in favor of the petitioner on 29th December 2011.
But subject to compliance of certain formalities if required, Lordship.
Stop. The said respondent shall intimate the petitioner the formalities that are required to be complied for effecting the necessary corrections. Stop. Steps shall be taken in the matter at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Disposed.
Grateful, Lordship.
I appear for the petitioner, madam.
Yes.
This is, Lordship, for implementation of an order for demolition, my lord. Lordship, a demolition order was passed on 26th May 2017. Against that,
2017.
against that, a building tribunal appeal was preferred before the building tribunal, my lord. That was rejected. That appeal was rejected on 26th May 2022. Lordship, we have thereafter given intimation that please carry out the demolition work because there is no appeal pending. The appeal has been dismissed.
Please show me the portions that are to be demolished.
Entire
The
building.
entire building. my lord.
Entire building. How big is it?
4 story. G+4, 5 story.
5-storied building. Which area?
This is Iqbalpur.
Ismail Ostagar.
It's under Iqbalpur police station. Page 56,
It is
Lordship.
to be demolished. It is to be
Yes.
demolished because we are in process and we have taken certain steps.
What are the processes from 2022 till 2023 you will have taken for demolition?
2022 to 2023, my lord, I find my lord, order of the building tribunal on 9th of July 2022. 4th August 2022, action was taken, partial demolition has been effected. And then, my lord, the further action my lord, could not be effected. The police has been intimated to get the premises vacated. This is the position.
Can the corporation sit tight?
Well, I am not sitting tight because we are, my lord, seeking the police assistance to get the premises vacated. Dismiss again. July, July 22 to Joshua. Joshua 22 থেকে কি করেছে? আমি ঘুমিয়েছিলাম। ফালতু।
Please come.
Which was the police?
The order of demolition passed by the
What is the affidavit of service, Lordship?
who passed the order of demolition? Special officer. Passed by the special officer within bracket building on 26th May 2017 was affirmed by the Municipal Building Tribunal
Page 56.
on 26th May 2022.
Same.
Stop. The building in question is at 4A by H by 1 by 1 Ismail Ostagar Lane, Ward number 79, Borough 9, under jurisdiction of Kolkata Municipal Corporation. Stop. The petitioner seeks implementation of the order of demolition. Stop. Next. Learned advocate representing the Kolkata Municipal Corporation admits that the G+4-storied building is an absolute illegal and unauthorized construction raised without obtaining any sanction from the corporation. Stop. It has been admitted that the entire building is liable to be demolished. Stop. The corporation took steps for demolition and caused partial demolition on
The partial demolition is only with respect to the guard walls around the water reservoirs. The sinking
when did
water
the
reservoirs.
partial demolition on
Demolition
4th
at all.
August 2022 with the assistance of Iqbalpur police station. Stop. The entire demolition, however, is yet to be effected. Stop. Next. It has been submitted that the demolition could not be carried out because the structure in question is occupied. Stop. Police has been requested to vacate the premises in aid of demolition. Stop. Next. Learned advocate representing the officer in charge, Iqbalpur police station, submits upon instruction that the Iqbalpur police station received a letter on 10th May 2023 requesting 23 with a request to vacate the premises by removing the occupiers of the unauthorized portion. Stop. The police instructed the concerned occupants to vacate the subject premises. Stop. Next. It appears from the instruction received from the corporation and the police that despite being aware of the order passed by the building tribunal permitting demolition of the unauthorized construction, the same could not be implemented as the structure in question is occupied. Stop. Next. The police is liable to take steps for vacating the premises in question so that the order of demolition can be implemented. Stop. Next. The police has forwarded the instruction that the occupiers were already intimated to vacate the subject premises. In May 20, by communication dated 10th May 2023. Stop. Next. The police is directed to proceed with vacating the subject premises and intimate the corporation the date and time when the police will visit the premises for removing any person who is occupying the unauthorizedly constructed portion to the men and agents of the Kolkata Municipal Corporation so that the vacating and the demolition can go on simultaneously. Stop. Next. The officer in charge, Iqbalpur Police Station, will be at liberty to seek for adequate police protection from the superior authority. Stop. The Kolkata Municipal Corporation shall ensure that the subject premises is demolished at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. The unauthorized occupants are restrained from causing any interference with the demolition program that will be carried on in compliance of the direction passed by this court. Stop. Let a compliance report be filed before this court. On 14th of September 2023. Report filed by the officer in charge, Iqbalpur Police Station, signed on 16th May 2023, be written with the records.
I'm great.
My lord, I am appearing on behalf of the petitioner, my lord. And my lord, I am praying for my lord's small indulgence, my lord, for correction, my lord, in my lord's order dated 29th August 2022, my lord. My lord, only in place of respondent number 3, it will be respondent number 4, my lord. And the respondent number 4 is controller of finance, my lord. Only the direction will be on him.
নামটা দিয়ে দেবেন।
Why did it take so long for you to detect the error?
My lord, praying for your benevolence, my lord. My lord, I
The
did not-
benevolence is something else. Because the time within which the order was to be complied is long over. Right?
Yes, my
So
lord.
what did you do?
Yes, my lord, it was a mistake on our part, my lord, and my senior counsel, I am led by Mr. Bhagavat Chaudhary in this matter, my lord. And my lord, he is very sick and on medical leave, which is why he could not appear today, my lord.
No, let him not appear. But why was this error not detected earlier?
Yes, my lord.
The matter has appeared in the list.
ঠিক আছে।
In the third line, third paragraph of the first page of the order dated 29th August 2022. Instead of respondent number 3, it will be respondent number 4.
In that case, same thing, but extension of time may be given.
Whatever is there is there.
Now from onwards now, respondent number 4 will now carry out the order.
Yes.
So
At a line
some
will get-
time may be given.
The respondent number 4 shall act in accordance with the direction passed in the order
Fine.
dated 29th August 2022 within a period of 12 weeks from the date of communication of this order.
Well,
Grateful, my lord. Highly obliged.
Accused have no right to come to
Miller 2 and 3, your lordship was taking up together. We had one sentence. I mean one sentence. Before Mr. Trivedi's judgment, I forget his surname.
Because everybody is used to calling me Dheeraj right
Yeah.
from the college days. So because of that.
But only one thing, Miller, Mr. Billodol Bhattacharya had alleged a suppression that the section 160 notice and the keeping in abeyance of these 160 notice has not been disclosed by us. Miller, this is on record before the before the Supreme Court. Yes. Before the Supreme Court, Miller, it was part of the SLP. And number 2 is, Miller, my case of, as I have argued, has got nothing to do with this 160 notice disclosure or non-disclosure. But this is the only thing. Yes, and of course, we have to hear.
No affidavit here also.
Here also.
Whatever submitted, excepting us, all from bar.
Here from bar. Yes.
Yes,
But if your lordship requires me, I can hand up, Miller, the copy of the.
I'll note down your submission.
Very well.
That will be enough.
Very well. I'm grateful.
I'm not sure whether I'll be given a hearing on
Reply.
the reply now on Kuntal's application.
Oh.
Well, so far, Mr. Banerjee, it's over. I am not going to make any submission. So for Kuntal's application is concerned, my lord, I would submit an infractuous application for 2 reasons. One is
Pradeep,
the order was
file.
the order was challenged, my lord, by state of West Bengal. First order of Mr. Banerjee saying personal bias. And the very same day, my lord, subsequently this matter had appeared. The state had preferred an SLP, challenging the order. The foundation was that it is the duty of the state to conduct an investigation on the basis of the Kuntal's letter, not the other agency. And my lord will be pleased to recollect the Honorable Supreme Court, my lord, did not entertain saying go back and file a review. while Supreme Court directing filing a review, that means the Supreme Court on merit did not find anything to interfere. Number one, that was that interfered earlier also. And that review was moved before this court. And that review was also dismissed by the Honorable Court, holding that the state government as such has no stake in the matter, and state government cannot claim that they have a right to conduct the investigation, which is the similar prayer made by Mr. Kuntal. This is an ongoing investigation. In ongoing investigation, intermingling facts have come out. Therefore, the question of transfer of investigation in any other agency does not arise. These are some. Oh, I am told me that Kuntal had also preferred an SLP. Yes. Lord, yeah, yes, I missed it. Kindly turn to Lord.
Page 60 of Can 6.
Page 60 of Can 6. Kuntal had also preferred an SLP.
They're also the same order to application.
Therefore, the order which has reached its finality, Lord, I would not repeat on same, cannot be interfered at this stage. These are my submission.
Relieve the judge, sir.
What?
To relieve the honorable judge from this matter.
One has been relieved. Do you want the second to be relieved also?
No, now my shots will be relieved from this matter.
My list has been held up. Prior to the vacation, all demolition proceedings are going on. Just imagine what is happening to them and what is happening to the court.
What is happening?
Yes.
My lord, only one submission.
Who are you?
I am
One thing, anything cannot be said due to live streaming.
Yes.
I got a ready answer before my lord.
Better don't say it. Yes.
my lord, I am first Kuntal Ghosh, my lord. I am led by Mr. Devashish Roy and Mr. Onindra Chatterjee. my
But
lord.
then you have finished your submission yesterday.
Only, my lord, in response to the submission led by my learned senior friend. My lord, my submission.
Reply is later on. Let this ED conclude first.
My lord, as far as maybe. Well, before I submit my OC copy.
Yes.
Before I start my submission, my lord, I am once again handing over to my lord a compilation just for the ready reference as to what I am referring to. My lord, what I could understand from the argument led by my learned senior friend on behalf of Kuntal Ghosh in the second, in the other can, it was, the first thing, that an FIR, rightly, wrongly, indifferently, a complaint was made by him, and it should be registered by the Hastings police station, and that is the prayer also. Petition. If my lord sees the application, my lord will find that apart from the intervening application, the application for interim relief has the prayer that his FIR should be registered. First petition, which is Can 3, is for intervention.
Addition of party.
They have said intervening application. The prayer goes to say, my lord, kindly comes to
implead
the applicant in the writ petition. And my lord, so much. Yes, my lord, I stand corrected. My lord.
The other one was for intervention.
I stand corrected. I am also getting
yes,
confused.
Application for addition of
I stand corrected. My lord, so it is for impleadment and Can 4.
Recalling.
He's wanting recalling first.
Yes.
And then, my lord, the ancillary part of the prayer is enforcement grant and the complaint filed by the applicant before the court and the Hastings police station shall not be given effect. My lord, that particular portion of the order should be recalled. So, my lord, now first, my lord, I come to the complaint itself. So, the first branch of submission which was made by my learned senior friend was that when a complaint is lodged, it needs to be registered. And once a complaint is registered, then lies my remedy under 482, 226 or 438. And then one more, he also pleaded that 41A is also going to come to my rescue. Without going into those points, my lord, first I would take, my lord, to the compilation which I had handed over to my lord yesterday, that complaint itself, if my lord kindly comes to page 4 of yesterday's compilation. This is the complaint, Lordship,
Yes.
dated 31st of March 2023. First complaint.
Yes.
Page 4. Now, my lord will kindly see, it is on a letterhead or on a format which is captioned as prisoner's petition, permitted under Jail Code Rule 615. On the top left hand, it's Bengal Form 5086. Madam, will kindly make a note of that.
Yes.
Now, my lord, this particular complaint was given to the format was given to the Kuntal. Kuntal wrote it in his own handwriting, which was subsequently forwarded to the learned court of the CBI at Alipur. Then my lord will kindly come to the complaint which was sent to the Hastings police station. That is at page, the compilation which I had given to my lord yesterday. Which starts from page 17 of yesterday's compilation. And that particular for relevant complaint is at page 20. My lord, it is again in the format of prisoner's petition, permitted under Jail Code 615, form number, West Bengal form number 5086. Now, my lord, in my respectful submission, as far as Jail Code is concerned, this particular complaint is not as per the Jail Code rules. Now, my lord, I will take today's compilation and my lord kindly takes up. Today's compilation will be page 25, my lord kindly comes. But the Jail Code starts at page 173. My lord will keep yesterday's compilation, that form, prisoners. My lord, in that particular form on which the complaint has been written, if my lord sees its prisoner's petition at page 4, and within bracket just below that,
615.
my lord, that is 605. That is the form number, but under that, permitted under Jail Code Rule 615. Now, my lord will kindly come to Jail Code 615.
Yes.
That is at page 25.
Yes.
Compilation. Malad has got it, Malad?
Yes.
Page 17. This is the excerpt of the Jail Code, which is being referred to. Now, Malad will kindly come to page 25. Malad has got page 25. Malad will see on the right hand corner, convict petition to the district magistrate or his erstwhile employer or official supervisor, WBJF number 27, WBF number 5086, which has been referred to that form. What it says, in the event of any convict, this particular petitioner is not a convict yet. In the event of any convict desiring to make a petition to the district magistrate or his late official superior or employers in matters of urgency relating to family affairs, civil suits, property, and the like, the superintendent, after due consideration, may at his discretion permit such petition and shall then countersign and forward it direct to the destination, provided that in no case shall any petition of this nature be forwarded direct to the High Court or to the state government. So, my lord, and therefore, my lord, will kindly see that prisoner's petition, which is at page 4, yesterday's. My lord, how it goes. From name, member, class, and then after that, this next, who was sentenced on. It's blank. So, my lord, as far as jail code is concerned, this cannot be treated as an FIR because this is not a legal complaint in the eyes of law as per the jail code. It could have been done. I am not advising the petitioner under any circumstances, because this technical issue was raised before my lord yesterday, that a complaint was there in proper form. So, my lord, my first answer to the submission of my learned senior friend made yesterday before my lord regarding the registration of complaint is this, that it is neither in proper form nor as per the code. So, it is not a complaint. Secondly, my lord, and my lord will kindly see, after due consideration, I will, if my lord once again goes to 615, after due consideration. How he considered, my lord, I will show it to my lord later, how the jail superintendent considered it. It was sent within 1 hour. Be that as it may, that is my second branch of submission. Now I come to my second branch. My lord, the first complaint, so-called complaint of 31st of March 2023, that is at page 4, which I was referring to before my lord, was made to the CBI court. Now, my lord, if the second branch of my submission is that a complaint made to the court alleging an offense, whether cognizable or non-cognizable, has to be treated as a complaint under section 200 by the learned magistrate or the learned court by referring it to her. Now, subsequently thereto, on the same cause of action, if a complaint is lodged to a police station, what should be its fate? A question I'm asking myself. Now, my lord, admittedly, the first complaint on 31st of March 2023 regarding the same incident was made in that wrong format, which is my first submission, but it was made before the court. Now, how they can take this plea that why my case was not registered with the Hastings police station? Second point. So, my lord, under these two circumstances, the two contentions and submission of my learned senior friend of mandatory registration of an FIR does not stand. Good. And the accused is trying to take two remedies simultaneously. So, my lord, the jail code does not permit the way in which the complaint has been lodged, because he is neither a convict and therefore he cannot. And my lord will now see my compilation, how the larger nexus, then I will come to the order. The gentleman who is the jail superintendent, he acts with utmost promptness. And this promptness has been shown by him in cases with regard to this scam, with regard to the other accused persons also. And these cases had gone before the learned trial court, PML court, where he was reprimanded. This matter also came to the knowledge of an honorable division bench of this honorable court, where again he was reprimanded for not following the jail code. Those judgments are also part of my compilation. My lord will kindly see. My lord, with today's compilation, my lord will kindly come to page 4 first. This is the order. It starts at page 1, my lord. Another accused person who was in jail custody, Mr. Parthocharya ji, in connection with the same scam. Here, my lord, he was allowed to, under the jail code, nobody is allowed to wear finger rings. He was allowed to wear and certain rules were compromised. And on page 4, my lord will kindly come. Paragraph 11. My lord will kindly see paragraph 11, my lord, the last but 4 lines. Last but 6 lines. Hence, the prayer for unconditional apology on the part of the Superintendent of Presidency Correctional Home is not accepted. His inaction to perform his duty as per the West Bengal Jail Code is condemned by the court. But as per section 83(6) of the West Bengal Service Act 1992, no prosecution shall lie against an officer or other employee of a correctional home under this section without the prior approval of the Inspector General of Correctional Home and Correctional Services. This is one instance. Second instance, Millet, is at page 9, Millet. Now, we kindly come to page 9, first paragraph. It is common knowledge there is opacity in the prison system, but when opacity interferes with implementation of judicial orders, the court cannot turn a blind eye. Now, my lord will kindly come to page 13, paragraph 17. None of these rules would justify the conduct of the superintendent to avoid the clear mandate of code that the under trial be not shifted for institutional treatment in jail hospital or any other hospital without express medical advice for institutionalized treatment. This code does not find even a shadow of justification emanating either from the aforesaid rules or the memo dated 14/12/2021 to permit the superintendent to construe the order dated 29/8/2021 in a different manner. There is patent violation of the order by permitting the under trial to remain in jail hospital without medical advice. Only under the threat of contempt did the superintendent grudgingly shift the under trial from jail hospital to the jail ward. This constitutes willful violation and order and cannot be excused as an inadvertent or technical breach. The intention of superintendent to keep the under trial in jail hospital is also not bona fide. He intended to violate the order of the court and to persist the ruse of precarious health and hospitalization. Thereby, he avoided the physical attendance in court and proposed the preferential treatment of video conferencing, which is not ordinarily made available to other under trials. The purpose of avoiding the court order is not innocuous, but prompted with the ulterior motive to give special treatment to an under trial. This is what has happened in this case also. This particular gentleman, how it happened, why I am telling you, my lord will kindly come to yesterday's compilation. A complaint was not allowed to be lodged in a hot haste manner on the 31st. I will not repeat. 29th, triggering of incident. 31st, a complaint has to be lodged. It was lodged not following the code. And how fast? If again, my lord, I will again come to that. I will not want my lord to go, but then it has been said in 615, after due consideration. That is the word. He has to consider and then he has to forward. Here, consideration takes a back seat. Even the jail code is not followed. And Millard, it was forwarded to the CBI court, Millard, page 3, if my lord kindly sees. My lord, page 3, Millard has got it.
Page 3 of?
My lord, yesterday's compilation.
Yes.
My lord will kindly see. Government of West Bengal, Superintendent Presidency Correctional Home has signed it, sent it on 31st of March 2023, and it has reached the court on 31st March 2023 as the seal is depicted on top. Millard, what has happened, Millard, can understand the promptness without following the jail code, without any deliberation on any other issues. It was with great promptness, it was forwarded. Now, Millard will kindly see at page, once again come to page 18. Page 18 of the same compilation, which is before my lord today.
Yes.
The same promptness was there with regard to the April 1st, 2023 complaint. It was emailed at 1:52 p.m. That is during the afternoon. So, my lord, the special treatment is there. And, my lord, the third branch of, so, my lord, first is, my lord, that this is no complaint in the eyes of law, because it is in violation to the jail code, which is only available. This particular, as per the jail code, is available only to a convict. He is still an accused and not an undeterred. Now, my lord, secondly, the first complaint before the magistrate, and second before the Hastings police station. Now, my lord, as far as the third branch of submission of my learned senior friend is concerned, he tried to that Enforcement Directorate had gone before the Honorable Court, Honorable Single Judge. Now, whether the Honorable Single Judge could have exercised his power under 226 or not was one of the contentions. Now, my lord, in my respectful submission, my lord, there are two judgments of this Honorable Court of a coordinate bench of my Lord Justice Mantha, my lord. In the case of Sri Shwendu Adhikari, my lord, two cases, my lord, where FIR is being lodged, my lord, and it has been decided by this Honorable Court. My lord will kindly, that is, my lord, WPA number 11803 of 2021. Now, my lord will kindly see. Compare with this. तो कब देंगे? रात को थोड़ी ना देंगे। क्या my lord? So, my lord, it has been categorically, my lord, I will not take, my lord, the relevant paragraphs with regard to 226, my lord, and court monitored investigation with the leave of the court. Everything has been taken care. Now, my lord will kindly see alternative efficacious remedy which was available to the authority. They availed that by going and mentioning the matter before the Honorable Single Judge. Honorable Single Judge allowed them to file an application, and they were very much within their right to file an application before the Honorable Single Judge in view of this judgment and the other judgment we are going to cite, my lord. And, my lord, it was not with regard to shielding any of its officers only, my lord. It was with regard to protecting the investigation, which should go on in a streamlined manner. And, my lord, that particular order passed by the Honorable Single Judge was interim in nature, because it was made returnable on the 20th of April. It was passed on the 13th, 14, 15, 16 being holidays. Everybody had a right to go and address the Honorable Single Judge on these issues. But at that point of time, when these FIRs or these complaints were being lodged, in order to deter the investigation, the Honorable Single Judge was very much within his jurisdiction, right, under Article 226, because he was exercising his powers under Article 226 in connection with an investigation. And we could make an application there because we had been added a party into all the pending litigations by order of the Honorable Single Judge, Millard. And therefore, Millard, where it was specifically said that we can go on with the investigation with regard to the money trail. That order was passed, Millard, on 14th of December 2022 in Sitabuddin and others versus State of West Bengal. And that has been referred to by the petitioner himself. So, Millard, the efficacious remedy which was available to us, alternative efficacious remedy, considering the urgency, was going before the Honorable Single Judge.
Which portion of the order of Justice Mantha are you relying upon?
My lord, we have marked it, my lord. I apologize, my lord, we have marked it, my lord. It starts from, my lord, if my lord kindly. From page 4 onwards, my lord. We have marked it. Now, my lord, the
Yes.
judgment which was cited by my learned senior friend of the division bench of this honorable court, paragraph 10. That was Lord Kushal Agarwal versus Mahendra Kumar Jain. Yesterday, my lord. Paragraph 10 refers to WN Chadda's case. My lord, Mat 922 of 2022.
Yes.
My lord, will kindly take page 7, paragraph 10, which was relied upon by my learned senior friend. But it says, my lord, Honorable Supreme Court in the matter of WN Chadda, in paragraph 92, has held that the accused has no right to have any say as regard the manner and method of investigation, and also has no participation as a matter of right during the course of investigation of a case instituted on a police report till the investigation culminates in filing of a final report under section 173(2) of the Code of Civil Procedure. Here, my lord, the accused persons, rather the persons who have been named in the complaint, because FIR has not been registered, so they are not accused persons, were not petitioners before the honorable single judge. It was the department which went with an application that, in order to throttle the investigation or thwart the investigation and for seamless movement of the investigation, because time is the essence of the investigation. Each and every time the persons who are apprehensive are coming to know about the process and the progress of the investigation, they are coming up with some method which are dubious in nature to stop or stall or create hurdles on the prosecution. Therefore, our department itself had no other alternative efficacious remedy but to go before the honorable single judge for this purpose. So, in my respectful submission, my lord, the contentions of my learned senior friend on the technical issues of registering an FIR, accused not being heard, or the honorable judge not having jurisdiction does not stand good. I'm grateful. And my lord, if my lord, my lord, we have got, my lord,
Of the investigation.
my lord, we have got progress of the investigation, my lord, we have got in a sealed cover all the relevant papers, my lord, which we have got, which is for my lord.
Yes.
And my lord, as far as my instructions are concerned from the department, my lord, as far as my lord, as far as money trail is concerned, we look after that, my lord. So, my lord, as far as on this point, at this point of time, my lord, as far as that speech and other things are concerned, we have not started because money trail has not been found. But we are investigating, my lord. Whatever progress is made, my lord, we will file a report pursuant to my lord's direction. And my lord, in the sealed cover, my lord, we have put in all the relevant papers. We have put in all the papers, my lord, which is for my lord's in the sealed cover, my lord, which will depict, my lord, whatever investigation and how we have carried on. It's a sealed cover.
Keep it, I'll see it later on.
Right.
Yes. Reply.
My lord, I don't know which amplifier the ED is using, it's Wolfgang or Bose. Amplification is going on. My lord, now it has come out that I, in collusion with the superintendent of the correctional home, have got or created these documents, these complaints. My lord, no such allegation was there in the complaint. My lord, I had told your lordship, forensic postmortem of my complaint cannot be done, could not have been done by Justice Ganguly, neither can be done by your lordship. Mr.
Dheeraj Trivedi.
Chaturvedi bolbo. My lord, my learned friend has relied upon a judgment delivered by Justice Mantha in the case of Subhendu Adhikari, although he has not served me a copy, it is an unreported judgment. But I gather that Justice Mantha had passed that order, exercising his jurisdiction under Group 9 of the writ, classification of the writ court. This is a residuary. My lord, it is my forensic examination. If he says, my lord, my FIR is not tenable in the eye of law, then what prompted him to move the application at the first instance? And who is going to decide this? Without hearing me, without adding me as a party, my complaint will be decided. My complaint will be quashed. And it was the only efficacious remedy. Why? Justice Mantha had put a padlock in his door, or Justice Bibek Chaudhary had said no 482 applications. Or Justice Devanshu Vasak had closed the door for 438 applications. I have specifically named some certain persons. My lord, whether it was through a proper channel, whether it is maintainable, all this forensic postmortem can be done. His prayer actually is for quashing. Maybe his prayer is very innocuous, any appropriate order. But what he is amplifying, his prayer boils down to that. But my complaint is not maintainable or not, it does not stand in the eye of law.
Goes into the merits of my complaint.
He is challenging the merits of my complaint. This is addressing your lordships as if a 482 application or an application under 226 praying for quashing of my complaint.
The PMLA doesn't give them a right
My lord,
to custody.
this ED or the officers of the ED doesn't have any immunity. Whether they're investigating PMLA or customs cases.
They don't have.
No, my lord. No. I have a client. It was his, it was their investigating officer, prime investigating officer of the Rose Valley, Manoj Kumar. He was facing a prosecution by the state agency.
No, show me the law. What does the law say?
My lord, let him show the law. He has the immunity. The PMLA Act does not say about that. Only the armed forces under the Code of Criminal Procedure has a protection. I mean, the three forces, Army, Navy, and the Air Force. Your lordship will see that it is there inbuilt. ED doesn't have any, ED, CBI doesn't have any immunity.
NCB also, Samir Wankhede. FIR file.
We are deviating from the main topic. That is what recalling.
No,
it is recalling.
You have finished. His prime officer, Manoj Kumar, who was the investigating officer in Rose Valley, is an accused. I have got him discharged. That's a different issue altogether.
There is no reply to
Please come.
There is no reply why I was not heard, and I am saying.
Reply to why he was not heard, my lord. The matter was returnable on the 20th before the Honorable Single Judge.
Please come.
Why did you go there?
I did not go. They went to the Honorable Supreme Court.
Oh, Supreme Court sent you. Show me the order.
You went. Sir, I don't make frivolous submissions. I have said you went to Honorable Supreme Court.
Sealed envelope handed over by the learned advocate representing the Enforcement Directorate in court today is taken on record. Stop. The seal is yet to be opened. Stop. Where is Mr. Bhattacharya? CID, your report.
It has been
CBI's report.
No seal cover procedure.
Go. I will reply.
Objection record.
Yesterday, there was a direction upon Mr. Bhattacharya. He said that he'll come up with a status report.
Yes. You could time and again is saying.
Achha. Hearing stands concluded. Judgment is reserved.
I'm grateful.
Seal cover objection.
वो बोल में ना दादा बोल में ना I know he knows.
बोले चीजें अपने
दादा आप बोलिएगा ये बात.
लिखिए.
It doesn't go.
You have to
with
go.
your stature. It doesn't go with your stature.
Well, this silk cover practice now is being deprecated by the Honorable Apex Court.
What thing?
This silk cover.
Sealed cover. And that is in other matters, not here. Investigation is going on.
What is this
The privilege document.
Let us see what is there because I have not seen it myself. What is
Yes,
there?
I'm grateful, my lord. My lord's leave.
Your Lordship, Mr. Shomu Majumdar is leading me. He's coming me a short pass over, Your Lordship.
Leading you for whom?
For the petitioner, Your Lordship.
Where is your brief? Where is your brief? Leader will have his own brief. Where is your brief? What is the matter about?
It is about that my house is dilapidating, Your Lordship.
Are you the advocate on record?
No, Your Lordship.
Where is the on record?
She's coming, Your Lordship. She's in another court,
My
Your
lord.
Lordship.
Mr. Achinto Kumar Banerjee appearing for the KMC. He on court number 16 on the legs, my lord.
Yes.
We're praying for not to down, my lord. He has the report.
On legs, not today. Urgent motion before the vacation.
So kindly fix it too then, my lord.
No, no.
I have been instructed to.
I have followed. You have been instructed, you are making submission, but the court has to take a decision what to do.
My lord.
And Mr. Banerjee is always assisted by juniors. Where is the junior? Where is the on record?
She's coming, Your Lordship. She's in another court.
Cannot help. Not today. Call the next matter.
My lord.
You should solve short pass over, Your Lordship.
Get ready. Don't take only adjournments.
My lord, I am for the state.
Where is the petitioner? None appears on behalf of the petitioner at the time of call. No accommodation sought. List after the ensuing summer vacation. The state is represented by the learned advocate. 6 same orders, state is not there.
My lord, I declare appeared for the Bongaon municipality.
I'm for the petitioner. my lord.
For
Bongaon municipality.
Bongaon Municipal.
I'm for the petitioner. My lord, the allegation is that the Bongaon municipality is constructing illegally, encroaching my property. Representation made, my lord, at page 29 and also at page 33.
What are the photographs you have annexed?
There are some photographs, my lord, showing that there was the vacant land and the construction is going on. Subsequently, after the filing of this petition, they have speed up their work and
I can see a road.
yes,
That's the Joshua Road, my lord.
road.
Road. And
After road, there is my property. My property, my.
is it a vacant land?
Yes, my property, my house, then my vacant land, then my lord road.
Yes.
They are constructing on the road. This is the National Highway Authority of National Highway 35 and encroaching my vacant land. This is
So there is neither the municipality's land nor the municipal road. Is the National Highway Authority a party?
Yes.
no, it's not party.
Yes, the Assistant Engineer National Highway Authority, PWD Road. Response number 4.
Yes.
Are you making unauthorized
It
construction?
is not unauthorized construction, my lord. Kindly see, my lord.
these are few photographs and these are the letters which we have sent to the National Highway Authority. May I
What are
please-
you constructing?
My lord, what we are doing a beautification project. What the fact is, my lord, my instruction is that the petitioner, the building which presently petitioner is residing, that building is also encroaching the National Highway Authority land. At least 11 feet of the petitioner's land, petitioner's building is encroaching the National Highway Authority land. Now, presently, few months before, my lord, the petitioner approached the municipality with a fresh plan that he is going to construct some building in the land where we are making this beautification project, my lord. We find out that this is a National Highway Authority land, so we refused the plan, we returned it. Then, my lord, we undertake this project so that, my lord, the land can be, my lord, protected, and that's what we have written to the National Highway Authority of India also. Kindly
And
see, my
did
lord,
the National Highway Authority permit you to beautify their land?
my lord, we have said that they on various occasions, my lord, they send us notice that this land has been encroached. You do not give them trade license and everything. We approach them that if the encroachment is there, already encroached, then it is not possible for the municipality to remove the encroachments. So before that, my lord, in various municipalities also, my lord, where there is a public land which can be encroached, there are beautification projects, my lord, constructed. These are all temporary projects. Later on, for the, my lord, the widening of the road, if the land is required by the PWD or by the transport department or the road department, my lord, we at that point of time, we give that to we demolish that and we give it to the, my lord, the appropriate authority. That's what we have written, my lord. Kindly see, my lord, my first letter to the Chief Engineer, Regional Officer, 8th May 2023, paragraph 4 onwards, my lord. May I read, my lord?
Yes.
That the Bongaon municipality has also done beautification work to prevent visual pollution and illegal encroachment in many areas beside National Highway as well as other roads. As a result, illegal encroachment of National Highway and other road has been prevented in many cases. That your office has already been informed about our proposed work, that it is making a model of the national emblem of our country, Ashok Stamb. It is not a model of a political stroke religious or any other personality. After all this is being done on a dead tree, we have no plans to move it from its present location. The adjacent to the proposed site, there is a vacant and dangerous place where there is a possibility of vehicle falling or accident at any moment. Temporary beautification is planned by filling the soil to avoid any accident at that place. Along with other municipal services, Bongaon municipality has done many such temporary beautification works beside the roads. That it is alleged that Rohit Shu, son of Shubroto Shu, that is the petitioner here in my lord, the owner of the adjacent building in the proposed area, has encroached the land of National Highway and built the house on forged documents. It has been learned that he is planning to occupy the proposed site. In fact, there are instances of such illegal constructions along the National Highway in Bongaon. Even in the areas of National Highway where ROB is proposed, illegal construction is taking place. Unfortunately, concerned office of your department is not taking any action in these cases. In some cases, only a GD is being lodged. The officials remain inactive, yielding to the pressure of the local influencers. This illegal construction should be demolished immediately. That the Bongaon municipality is ready to cooperate with the government regarding the work for widening the roads. Therefore, these roadside vacant places can be kept free from illegal encroachment by temporary beautification. If not, many problems may arise to remove these encroachments in the future. These temporary beautifications will be removed by Bongaon municipality in future for the purpose of widening of roads. That I would like to request you to kindly arrange a field visit from your office to the proposed area. Then the statement of this municipality will be clear. Further, I am to request you to kindly take appropriate action against those persons who have illegally occupied and constructed building on the land of National Highway by conducting a survey within Bongaon as soon as possible. So this is, my lord, our undertaking that for this purpose, my lord, we are doing it. And they are saying it is their land. We are saying now that that is not their land. If required, my lord, your lordship can direct the BLLRO, who is the respondent number 5, if I'm not wrong, my lord, respondent number 6, my lord, to conduct a inspection in presence of all the parties and file a report before your lordship.
I have also.
Where is the your representation mentioning the land details? LR tag number 26232933 29. LR Khotian.
LR tag number and LR Khotian number.
Isn't there any plot number? Dag and Khotian will be big numbers, will be big chunks of land. Where is the plot number?
They have purchased the land without demarcation, my lord.
I have also annexed my deed, my lord. I have annexed my deed.
Kindly
No,
see,
for the purpose of identification, whether the land is your land or the government's land, how can it be identified without a proper plot number?
Dag number is a plot number.
It is the same thing.
That's why it can be- that can be identified.
my lord, kindly see their deed once.
There, my lord.
Page
Yes.
15, page 15 once.
It is my deed.
Yes,
It is entirely, my lord, your lordship will get it, my lord, kindly see once.
It is a deed dated 1st of February 2010. And it is a chain deed of 27th June 1996.
where are the recitals?
The property line is 18, page 18.
And my lord, kindly see page 15, left side, Pৌরসভার জমি.
Page 15 left
My lord,
side.
yes, my lord, after the affidavit, the first annexure starts.
Yes,
Left side, my lord.
left side. পৌরসভার জমি.
This is something, my lord, which we have never seen in any recital or any deed, my lord. This is something, this is not beyond my knowledge. my lord.
Something new. 26232933. Dag number Shabek 2623 Hal Shabek. So is the municipal land?
No, no, no.
What? No, it is written over here পৌরসভার জমি.
My lord,
জেলা শহর পৌরসভা অন্তর্গত মৌজাত জয়পুর মালিক পশ্চিমবঙ্গ রাজ্য সরকারের পক্ষে. It's a vested land. See, your Topshil also says
Yes, my lord.
that's মৌজার পশ্চিমবঙ্গ রাজ্য সরকারের পক্ষে উত্তর সাচান সাচ
পূর্ণগমা পৌরসভা অন্তর্গত।
page 27, my lord.
page 18. Page 18.
That's the
schedule
mutation.
of
What
your
they're showing, that
deed.
is the mutation, my lord. Mutation does not call for, my lord.
Mutation does not mean anything with regard to your ownership.
My lord, what is left that is sold after uh,
No, the court is not convinced with your title of land.
page 27.
20?
27. This is the mutation.
This is the mutation.
Yes.
Mutation is not the own proof of ownership.
My lord,
So your mutation will not do. Tax receipt. Not the municipality. Mutation হলো কি করে? Payment of receipt, khajna receipt, nothing will do. Your title
Municipality is
is
taking
something.
from fees as occupier, my lord, since they are occupying there. There is shop also, my lord. I have given the my lord, the compilation to your lordship. The photographs are also there. There is a
Please come.
and my lord, the photographs also shown, my lord. There, his egress and ingress is, my lord. It is
The petitioner
there is
complains
no
that
disturbance.
municipality is raising illegal and unauthorized construction over his private property. Stuff. The petitioner has annexed the title deed, wherefrom it appears that the portion of the land which the petitioner claims to be his private land is the land of the municipality. Stuff. Next. The municipality,
I don't think I have to take Mr. Why this is thing.
the municipality has forwarded instruction to the learned advocate annexing a copy of the communication dated 8th May 2023 addressed to the chief engineer and regional officer,
এটা আমরা
Comma.
PWD কে দিই।
Ministry of Road Transport, Department of Roads,
The communication between
Department of Road Transport and Highways, wherein the municipality has disclosed its intention to beautify the area in question, to prevent visual pollution an illegal encroachment in the land which is absolutely by the side of the national highway. Stop. Next. The communication clearly mentions that there are illegal encroachers of the land of the national highway where constructions have been made based on false and forged documents. Stop. Next. From these submissions made on behalf of the parties and upon perusal of the materials on record, the court is not convinced with the submission made on behalf of the petitioner that he is the sole and absolute owner of the land in question. Stop. Next. The receipt showing mutation and deposit of tax in respect of the subject property is not the indication of title or ownership. Stop. Mutation merely relates to identifying the person primarily liable to pay tax. Stop. As the court is not convinced with the ownership of the petitioner in respect of the land in question, accordingly, there is no scope to entertain the writ petition. The same stands dismissed.
Madam, the instruction will remain with
Instruction provided by the Bonga municipality be written with the records.
I'm grateful, ma'am.
একটা লাইন add up করুন তো। Dismissal of the writ petition will, however, not stand in the way of the petitioner from approaching the proper forum seeking declaration of ownership right / title in respect of the subject property.
My lord, I am on behalf of the petitioner, my lord. My lord, on the last occasion, your lordship was pleased to direct the promoters to demolish the whole building. And it was been submitted by the corporation that only the pillars are standing. My lord, I am placing before your lordship the photographs.
My lord, may I say one thing, lordship?
Does it show that only the pillars are standing? With date and time, my lord.
This is the building.
This is the building, my lord. And on the last occasion, it was been submitted by the corporation that only the pillars are standing.
Let me see just.
My lord, I appear for the
The respondent number 11 was directed to remain personally present Who is the respondent number 11?
My lord,
Promoter?
my lord, I appear for the respondent number 11. My lord,
Yes.
I have,
Is
my
he
lord,
personally present?
my lord, may I say this? My lord, on the,
Personally present.
my lord, may I say this? My lord, not today, my lord, due to some personal difficulty, my lord, my instruction is, my lord, against the last order passed by your lordship. My lord, he has already preferred an appeal, and the honorable division bench is pleased to keep the matter today as item number 1 in the appellate side Item number before the 2. Item number 2. It was not been hard till yet. But it is
But then
expected.
has any order of stay been passed?
Well, we have obtained a leave. Well, a leave was granted, and the matter has been directed to appear today. The copy has been served to them. They are well aware of the fact. Well, I do not stand with regard to the demolition. I only say, well, to the extent that whether it remains with my responsibility or not, and only on the ground, well, the honorable division bench has considered that that they will hear the matter today. Lordship may can also check. Well, they have also agreed it's appearing today as item number 1.
Let the matter appear in the list. There is no difficulty. But why will the order, the direction is there for personal appearance? Why will he not be personally present in court? Where is the stay of the order?
Of course, kindly give me 1 or 2 day time. So far as the entire
Today.
So far as I beseech your lordship, I bow down to your lordship, so far as the entire
Order, you are required to comply.
my lord, so far
Advocates,
my lord.
they advocate for all these things.
Lordship.
Then you can never get the orders.
That is why, with the deepest respect, I say this.
Showing respect.
Malad,
This is utter disrespect.
It is not, it is not, lordship. Against that order, the appeal is preferred. That is my instruction.
Don't you obtain an order of stay?
That is why it is pending. It is to be hard today, it is to be hard today. Lordship, if desires, kindly keep it tomorrow. Or day after tomorrow, it is expected to be hard today. It's appearing as a list as item number 2, as a first item in the appeal application.
It's not putting any pressure upon the division bench to hear a matter.
Of course not. Of course not. Of course not.
Very sure.
Of course not. Of course, that is what my submission.
The person who was directed to be present ought to have been present in court. Tell him to come at 2 o'clock.
Kindly.
Tell him to come. We will see later on.
Kindly appreciate this thing. This is against this order. There is already an appeal preferred, and the appeal is in list. Kindly keep it tomorrow.
2 p.m. Call the next matter, please.
Kindly keep it at 3 p.m. Kindly keep it at 3 p.m.
Item 10.
Kindly keep it at 3 p.m.
Please.
The appellate is to be taken up at 2 p.m. Kindly keep it at 3 p.m.
In my able petition,
yes, please.
From last occasion, my lord, your lordship directed me to serve the private respondents who are not made parties, my lord, and we have served, my lord. This appeal service I have filed, my lord.
Boranagar municipality. Where is Boranagar municipality? You also appear? When?
And briefed in this one.
My lord, it is against an order of refusal of mutation, my lord.
Refusal of mutation.
My lord, father gifted her the property to in favor of her daughter, in favor of his daughter, my lord. Daughter made application for mutation.
And who are the objectors?
Well, they are the earlier owners, my lord.
Earlier owners
of the land.
Are they your family members or something?
No. They are the erstwhile owners, my lord.
Erstwhile owners sold it to your father?
Yes.
Father has expired?
No, father is living now.
Father is a party?
No, father is not party, my lord. Father is living, my lord. Father executed deed of gift in my favor. In terms
registered deed of gift?
Registered deed of gift.
Not challenged by anybody?
Not challenged by anyone.
All right.
Yes. My lord, then I made application for mutation, my lord. That application mutation has been rejected, my lord.
Rejected?
Yes, my lord.
What is the ground of rejection?
Ground of rejection that
somebody objected.
No, not somebody objected. The objection or they are saying that father is not the owner, my lord. My lord, the land depot
father is not the owner.
Yes, my land depot officer mutated in my name, my lord.
No, not mutation.
Yes, my lord. Land depot officer mutated in mine. I have annexed that application, my lord.
So what do you expect the municipality to do? To enter and decide upon the title of a party?
No, that they have done so, my lord. They have posted the title. When the land depot department had mutated my name in respect of the plot of land, my lord, they are posting my title, my lord. How they can municipality and how they can post my title, my lord.
The objectors were directed to be impleaded. Where is the impleadment?
My lord, on the earlier occasion, my lord, names are not there, my lord. I have included them, not in the original petition.
Yes, please do.
Yes, my lord, I am doing that.
Three persons are there, my lord. I've included them, my lord, 5, 6, and 7, my lord. And all of them have received, my lord. That's all.
Show me the impugned order once.
Yes, my lord. That is page 66, my lord.
26.
66, double 6, my lord.
666. What is the error in the order?
Well, not error, but he has disputed the area of the plots. But that has been decided by the land reports officer, my lord. Kindly come to page 58, my lord. Page 38, my lord. On page 32 letter written by the commissioner to the SLRO Barakpur, my lord, requesting him
Yes.
to finally dispute, my lord, whether there is any residual land of late Shital Prasad Das, my lord, page 31, my lord, 32, my lord, page 32, my lord. Residual land of late Shital Prasad Das, the erstwhile owner of bag numbers 295 by 397 of Kotia number 386, 295 by 396, Kotia number 146, 296 and 296 by 390 of Kotia number 152, after he had sold his lands by sale deed or otherwise. Then my physical demarcation of log numbers 296 and 295. And identification of land purchased by AMRITA. AMRITA is father, my lord. But then my come to page, my lord, 38, my lord. It was my lord, measured by the persons of the land Revenue department, my lord. Kindly come to page 35, my lord. Page 35 or certified copy.
Yes.
Well, for middle portion, my lord, rest of allegedly disputed land measuring 13 feet mark will be from the number 296 is the northern is portion of land purchased by Semin Pal in the number 296. That other owners of the
Was this document produced at the time
yes,
of
ma'am.
hearing?
Yes, ma'am.
It was considered.
Yes.
So what will the authority do?
They have not considered these documents. They have not considered. They are saying I have not purchased, ma'am. But
No, they have
purchased,
considered it and come to an opinion that you have not purchased it.
but I have purchased it and my name has mutated by land Revenue department, my lord. Now kindly come to page 58, my lord. They are the authority to see my title, my lord. Page 58, my lord, there's the mutation certificate, my lord, in my name. Can you see, my lord? Mutated area 1.4.1.4.
Kindly give
Petitioner is
direction for
aggrieved.
affidavits.
The petitioner is aggrieved by the order dated 26th of February 2019, passed by the executive officer, Baranagar municipality, rejecting her prayer for mutation. Stop. The order in question is a detailed one. Stop. The facts and figures in connection with the land in question are mentioned therein. Stop. The municipality was of the opinion that on physical measurement, the quantum of the land which the father of the petitioner purchased was less than the land which the father of the petitioner sold and thereafter gifted to the petitioner, being his daughter. Stop. The impugned order records that at the time of hearing, the father of the petitioner admitted in presence of all the persons present in the hearing that the plot of land in question was totally vacant, and he himself made the boundary wall in the absence of the seller. Stop. The municipality not being satisfied with the title of the father of the petitioner, refused to mutate the property in favor of the petitioner. Stop. Next. It appears that the order was passed, that the impugned order was passed upon perusal of all materials placed before the municipality. Stop. Next. The father of the petitioner is still alive. Stop. He has not been impleaded as party in the instant writ petition. Stop. The objectors who objected to the mutation in favor of the petitioner were later on impleaded as party under the direction passed by the court, and copy of the writ petition served upon them. Stop. None appears to oppose the prayer of the petitioner. Stop. Next. On a perusal of the documents annexed to the writ petition, the court is not satisfied with the submission made on behalf of the petitioner with regard to her title. With regard to the manner in which she derived title in respect of the subject property. Stop. The property in question was gifted by the father of the petitioner to the petitioner. Stop. The municipality has questioned the title of the donor of the property. Stop. Remanding the matter back to the municipality will not serve any purpose. Stop. Municipality will not be the appropriate authority to decide the right title and interest of the parties in connection with a subject plot of land. Stop. Next. In view of the above, no relief can be granted to the petitioner in the instant case. The writ petition fails and is hereby dismissed. Dismissal of the writ petition will, however, not stand in the way of the petitioner from approaching the appropriate civil court for declaration of right, title, and interest in respect of the subject property in accordance with law, if so advised. Service taken on record. Please implead the private respondents.
Lordship, I am appearing on behalf of the petitioner. It's a name change petition. This petition is for changing my name. Petitioner number's one name has undergone a change in the year 2020, 23rd of November. I have served everybody. On the last occasion, Your Lordship had directed me to serve on respondent numbers 1 to 4, and they had submitted that they have not received it. I have a copy of a letter on which they have signed that they have received. They're appearing also. And with regards to respondent numbers 5 to 9, they have also received it. Service was filed. It's a very simplicity application. If Your Lordship takes page 13 of the application, the Ministry of Corporate Affairs, Register of Companies, they have given a certificate that my name has been changed from SKCL Wealth Management Private Limited to SKCL Capital Private Limited.
Page 13 of the
My petition, application petition.
Application. Is it can 4?
Yes, Your Lordship, can 4. Lordship will see the Ministry of Corporate Affairs. They have given a declaration that the name has changed from SKCL Wealth Management Private Limited to SKCL Capital Private Limited. And Lordship will also find the CIN number, corporate identification number. That is the same. Now I am seeking amendment to the effect which I have indicated in page 11 of the schedule. Page 11, that is the proposed amendment which I am seeking. Just a formal change of name in the cost title and the petition. If Your Lordship is pleased to allow this amendment, Your Lordship will also grant the petition number 2, who's the authorized officer, to re-verify it. That is my second prayer. Prayer B. No objection.
You are for the corporation?
Yes, no problem. This amendment can be carried out.
It can be carried out. What is the main prayer in the writ?
Main prayer, there is a lot to submit. Complaints of illegal construction, inspection was conducted, and a school and a central government office was found over there.
Constructed unauthorizedly?
No, at least the school has been running for substantial number of years, and the other is a central government office.
And that is also running for quite some time.
Yes. Kalithon institution has been impleted also. That's particular.
Yes, but then the corporation failed to detect any unauthorized construction.
The person who represented the petition
Stop. Next. It has been submitted that the name of the petitioner company has been changed from SKCL Wealth Management Private Limited to SKCL Capital Private Limited with effect from the date of issuance of the certificate. Stop. The certificate in question was issued on 23rd November 2020 by the Registrar of Companies Kolkata. Stop. The corporate identification number of the company is mentioned in the said certificate. Stop. Next. Learned advocate representing the Kolkata Municipal Corporation does not have any objection to the amendment being carried out in terms of the schedule of the application. Stop. In view of the above, the department is directed to make necessary amendment as mentioned in the schedule appearing at page 11 of Can 4 of 2023. Can disposed of.
Your Lordship will also grant me leave to reaffirm. Prayer be, Your Lordship.
The department will carry out the necessary correction. Nothing is required to be done. And paragraph, in the writ petition, the petitioner has alleged illegal and unauthorized construction at the instance of the private respondents. Stop. Do you have a report of an?
The report was in all probability filed before Honorable Justice Shampa Sharkar. I remember, Madam. Otherwise, I have to produce. I'll go through the file and assert.
I don't find any. And the matter was possibly appearing before Justice Kapoor
also. Yes.
and not before Justice Sharkar.
It had appeared.
I do not see any endorsement of Justice Sharkar.
Well, I'll ascertain, Madam, but I'm sure an inspection was carried out and my other junior in this matter was earlier a different advocate, Madam. It may be with him also. Dijodash.
It is better you file a report.
Yes. I'll file the report of the inspection already done.
Yes. The
My instructions are that it has not been filed.
not been filed.
Not been filed.
The corporation was directed to conduct an inspection and file a report before this court. Stop. Learned advocate for the corporation submits that the inspection was held and a report prepared. Stop. Next. Let the report be filed before this court on the adjourned date. Stop. List on when? 13th of June. When the matter will appear in the list marked for orders.
Your Lordship will kindly indulge in granting me the leave. The petitioner number 2 has to reaffirm the affidavit. The department cannot.
The cost title change will not necessitate that. Merely a change in.
It is the change in the cost title. The name of the petitioner will be deleted by the.
Yes, the affidavit will also change, Your Lordship. Because the name of the authorized officer.
The name of the authorized
It
officer
is the
will
same.
change.
No. Your Lordship, the company's name, since the company's name has changed.
No, doesn't matter. Let us see if any problem arises the next
Lordship,
time.
much obliged. Grateful.
What are the other cans for? Are you aware what are the other cans for?
Holding of the inspection, one other can was.
I can see 1, 2, 3, 4. I disposed of 4, the amendment. What about 1, 2, 3? Did you file? Did the other side file?
I have to take instructions. I don't have it with me.
Check up whether they have been disposed of or not. Not disposed. What are they for?
One was for holding of the inspection. That is there. I've seen
Appropriate
that.
orders.
Of the inspection.
And that can be disposed of. What is the use of keeping that pending if you have already
The moment I
contacted?
file it, my lord will dispose that of.
Yes, your lordship will keep it on the next day. Your lordship.
Very well. Let it only 4 is disposed.
Much obliged.
My lord, I'm for the state.
Is the matter appearing today? Was it yesterday's matter? Vikram Hajra? Did the matter appear in the list yesterday? It's appearing by mistake, possibly. Twelve is appearing by mistake. It was taken up yesterday.
My lord, actually, when the matter was called up yesterday, I was just outside the courtroom, and when I entered into the courtroom, I found that the matter was already taken up. And your lordship had reason for the day, despite the fact that the matter yesterday was item number 7, and when the outside board was showing item number 3, there was no possibility that I could have known that item number 7 was going on.
No, but then the matter continued for nearly 30 minutes.
No, my lord, because the outside board, it showed item number 3 even after 4:30, even after your lordship rose for the day.
No, the court was here till 5:10 tomorrow, yesterday.
Yes, my lord, even after your lordship, I bear testimony to this fact, my lord. And after that, I just came into just to inquire about what was
What
the last,
time?
after your lordship rose for the day, yesterday.
What time?
After 5.
So what were you doing from 4:30 to 5 when the matter was being taken up?
My lord, I was just outside the courtroom.
For what good reason were you standing outside when the matter is being taken up by the court?
Because, my lord, the outside board was showing item number 3, but this
Very
item
well, cannot be helped. Yes, call the next matter, please.
Well, item 13, I beg to appear on the petitioner. The private testimony preferred an appeal, and the division bench, my lord, asked the municipality to show the order of, my lord, delegation. They could not produce it. For this reason, the matter remanded to the municipality for fresh hearing by the mayor.
The appeal has been disposed of. The writ will also go. Very well.
Time frame is there, 6 weeks. And date কবে ছিল গো?
3rd of
ডিভিশন বেঞ্চের অর্ডারটা 3rd of May. Under section 47, my lord, engineer is, my lord, have a power by delegation, but that order was not shown. That's that reason.
Please come. In view of the order passed by the Honorable Division Bench on 3rd May 2023, passed in Mat 638 of 2023 with IA number CAN 1 of 2023 within bracket Shondeep Chatterjee versus Probir Ghosh and others. Nothing remains to be decided in the present writ petition. Stop. The same stands disposed of. Order dated 3rd May 2023, passed by the Honorable Division Bench, be retained with the records.
Order to them.
My lord, I am appearing for the municipality, my lord.
I beg to appear for the petition.
My lord, earlier occasion, my lord, there was some directions upon the municipality, my lord. My lord, to comply with that directions, my lord, the municipality seeks some more times, my lord.
This is regarding construction of the water reservoir. What is the municipality thinking of? Acquiring the land?
So, my lord, my lord, they are trying to, my lord, acquire, my lord. They have talked with the office of the BLR, my lord. So, my lord, some times are required for the process, my lord. for the
Which process? What is the process the municipality is contemplating?
My lord, as per your lordship directions, my lord, first they have to measure the area. Thereafter, my lord, they have to decide regarding the compensation, my lord. So municipality requires 1 month time, my lord, for that.
Is the petitioner aware of any
Nothing. No measurement,
steps taken?
nothing. No communication whatsoever in these 4 weeks.
Why do you not
And
intimate the
thereafter, madam,
petitioner?
we wrote a letter to them that you have not, in pursuant to your lordship's direction, you have not taken any steps. Kindly convey
was
us.
directed to be engaged. How long does it take? The municipality has all the infrastructure. Then why is the municipality not acting?
Lordship, kindly consider some more time.
Why will this kindness be shown to you? There must be some reason to show some kindness. You show at least you have done 1% of the work, the court will show kindness. You have done nothing. You have only prayed for time. Why will the court grant you this time?
My lord, meeting was held, my lord, but
Show me the documents that the meeting was held. Any decision taken?
no, my lord, till date, my lord, no decision. Your lordship, kindly give my lord 1 month time, my lord. Within that time, my lord, the municipality will comply with your lordship's order, my lord.
This is the request made by the learned council. This is not upon instruction from the municipality.
Yes, my lord.
Then why are you making this submission? Your client will say you that I did not request you to make such a prayer. You will fall in trouble. As it is, 1 month is over. You want further 1 month. So you have to show some bona fide as to why the court will accept your contention. Isn't it?
Yes, my lord.
Then
Last chance may be given, my lord.
again, last chance.
In the meantime, my lord, what is happening, my lord? They
I
are
will give you more than one chance, is no difficulty, but then something positive has to be shown from your end that you are acting in terms of the court's order. Otherwise, no.
in the meantime, this plot relates to Ultodanga Mauja. And in the Golaghata Mauja, my lord, they have already constructed a reservoir, a party office, and a playground by
Whatever,
the municipality.
not connected with this matter.
Not with this. Another writ petition is pending.
Coming. Oh, it's pending. Where? At your end or in the court's end?
In the court's end.
It is there in
Yes,
it's
yes.
on the records of the court.
Yes.
Yes. Municipality is not doing anything.
Not doing anything. So here
Your
they are
conduct of
doing
the
same thing.
municipality is, I cannot accept it. I'll direct your officer to come to court. Please
My
come.
lord, your lordship kindly consider, my lord.
Learned advocate representing the
শকুনের মতো গিলে নিচ্ছে কি রে ভাই
municipality seeks a month's time to take further steps in compliance of the direction passed by the court on 18th April 2023. Stop. Learned advocate representing the petitioner submits that no steps whatsoever have been taken by the municipality to act in accordance with the direction passed by the court. Stop. Next. A notice was served upon the learned advocates representing the municipality and KMDA to take proper steps in accordance with the direction passed by the court. Stop. Next. The learned advocate for the municipality has not been able to produce any document to show that steps were taken in furtherance to the direction passed by this court on 18th April 2023. Stop. Only prayer has been made for adjourning the matter for a month. Stop. Such a prayer, devoid of the relevant documents, ought not to be accepted by the court. Stop. Next. The matter is peremptorily adjourned till 20th of June 2023. Stop. A responsible officer from the South Damdam municipality shall remain personally present in court with all relevant records to show the steps taken in compliance of the direction passed by this court on 18th April 2023. Learned advocate for the parties are directed to communicate this order to the municipality. The notice dated 11th May 2023, written by the learned advocate of the petitioner, addressed to the learned advocates representing South Damdam municipality and KMDA, be retained with the records.
I'm not being paced, my lord. What bothers us, my lord, my client's apprehension is they might go for further construction.
Assuming that is done,
It is already completed.
it-
Water is.
The- the-
it will be
আমার
taken
জমি
care of.
যাচ্ছে তো।
Oh, that's a
It
separate
will be
thing.
taken care of.
That's a
Kindly, my lord, just restrain them. I'm not saying that kindly restrain them.
The municipality is restrained from making any further construction over the subject plot of land
তারপরে সিভিল সুটে পাঠিয়ে দেবে তোমাদের
till the matter is finally decided by this court.
I'm deeply
Yes.
obliged.
I am appealing for the municipal.
I am open the petition. Why were you not there on the last occasion? The matter was called on.
I was. Pursuant to my lord's direction, the inspection held.
But then it was submitted that it is a sham inspection.
Kindly see the attendances.
No, attendance is all right.
Petitioner is, I have annexed photographs. And the attendance sheet, the petitioners and other respondents and other persons were present. Upon inspection, it is found that there is no more of the sewage water is discharged on the public land.
No.
No sewage water is discharged on the public land. Kindly see from photographs, my lord will find.
Why is the Kacha pipeline still there?
That is the in that cooperative, everybody has the own the soap kit. And that portion the outside is a kacha drain for rainwater.
You had issued a notice on 19th May 2021.
That we have complied with that already been demolished. That is earlier report said so. Earlier occasion we have submitted a report by destroying that. We requested the respondent to demolish that. If they did not do anything, we on our part we have demolished that chamber. In the earlier report we have submitted.
You have demolished a chamber, but the pipeline is there. Why is the pipeline there? Why don't you remove the pipeline? Page 21, it is your notice which says to demolish the pipeline.
My instruction, the entire the work has been
No, no. Submission is that only the chamber portion has been demolished, but the pipeline remains. And after you are gone, the pipeline will be again used. Why are you keeping this pipeline?
When we inspected, we found the sewage water is coming.
Yes, that time it was dry season. You did not find any sewerage water. The moment the rainy season will come, the monsoon water, sewerage water, everything will go. Why are you permitting this?
If the still the pipeline is there, I shall instruct the municipal authority to remove that.
Because that is your order. See page 21. So demolish the pipeline with intervening chamber. Act in accordance with your order. Page 21. Second paragraph.
No.
Have you seen? Do it. Please come. A report has been filed by the municipality, signed by the sanitary inspector, executive officer, and the sub-assistant engineer. In May 2023. Indicating that on inspection, it was found that no sewage water is discharged on the public land and no foul smell was felt at the spot. Stop. Learned advocate for the petitioner submits that the existing pipeline through which the sewage water was passing is yet to be demolished. Stop. Next. Learned advocate representing the yes. Pipeline is
private respondent land only.
the chamber was also within your land,
Yes,
but that was
No, my lord.
constructed illegally.
pipeline there.
The pipeline was going to the chamber.
Yes.
If the chamber is not there, what is the use of the pipeline?
In the rainy season, my residence house is the down floor. So all the water is stored and then water is the
Where do you flow the water from the land to where does it go? Where does the water flow to?
communication 7 times corporation.
Yes.
7 times information the Kharagpur municipality.
Yes.
Permission for permission.
Permission for what?
The water.
I cannot follow you. Please submit. What? Tell me what you saw.
Rainy season.
Yes.
Water is storage.
Where is the water stored in the rainy season?
My land.
Then?
Then pipeline
Yes.
in my private respondent.
You are using that pipeline for the flow of that water, and where does the water lead to? It was to the chamber. The chamber is gone. Now the water will be everywhere.
My understanding, the rainwater is going through the pipeline, and this is coming to the Kacha drain. That is most probably that is the.
I do not know.
That is in that society. Every unit holder has the soapkeep, and only rainwater is coming to the Kacha drain. But here the dispute arose. Some the sewage water is coming by installation of the pipeline by the private respondent. That was the complaint lodged by the petitioner. Now that the chamber, the destroyed, so that sewage
Water will not come.
Will not come. Only the rainwater will come in that way.
No, my lord.
That is
That is not the actual picture, my lord.
I do not know. Two flanks are there, my lord. This is the. Show it to your learned friend. Two flanks are there, 5 pipes and 4 intervening chambers. 4 chambers in their land. That is the road. And the pipeline is discharging water. One is in Kacha land, and one is in another person's land. That is my front land. Petitioner's front land.
Only we can do. Since the pipe installed on their land. Only we can assure that through that pipeline, no the sewage water coming in the Kachan. Otherwise, for removal of the
Pipeline should be removed, my lord. That is on the road. I can show the pictures, show the photographs. Learned advocate. They're misleading the court. Right, paragraph. The notice of Kharagpur municipality dated 19th May 2021 issued to the private respondent clearly mentions that the pipeline with the intervening chambers is to be demolished. Stop. Those steps have been taken for demolition of the chambers, but the pipeline is yet to be demolished. My lord, one interference, my lord. They demolished 2 chambers and partly 4 or 6 bricks were broken only. Another is intact. No, but then the chambers are not being used. Oh, continuously using, my lord.
No.
Continuously using.
My lord, kindly leave it. Special officer appointment and remuneration my client is paid. Actual picture is the.
Ki bolam? The learned advocate appearing for the petitioner disputes the fact that the chambers have been demolished. Stop. It has been submitted that the chambers are functioning on regular basis and only cosmetic demolition has been conducted. Stop. Learned advocate representing the private respondent denies this aforesaid submission and submits that the pipeline is being used only for flow of rainwater during the monsoon season. Stop. Next. It appears that the existence and use of the pipeline and the chambers are disputed by both the parties. Stop. Next. It will not be proper for the writ court to enter into an inquiry. Stop. The executive officer of the municipality is directed to ensure that no sewerage water flows through the pipeline and the chambers are not used for collection of sewerage water. Stop. The writ petition stands disposed of. My lord, kindly see this pipeline can be someone's place, my lord. Someone show it to your learned friend. My lord, this should be removed, my lord.
My lord, before rising, my lord, item number 5 and 6, I was busy in code number 28. My lord,
Item numbers?
5 and 6.
It has been posted after the vacation.
My lord, kindly make it to, tomorrow. I'm giving a fresh notice because the 84 years aged person is suffering, my lord.
You could have kept somebody over here.
Well, actually, all my juniors, one is suffering from COVID, another is hospital.
I do not know. You could have requested any of our friends to come.
Well,
Nobody was there.
Suddenly it was
Immediately prior to the vacation, is it
Well,
possible?
tomorrow, only 1 minute, only for the death certificate, 2 death certificate. Tomorrow, I'm giving a fresh notice. 84 years age.
Other side.
I don't know. I'm giving a fresh notice to them.
In item number 6, your lordship, it is Bidhannagar Municipal.
Bidhannagar.
And 5 also.
KMC.
Who is appearing for KMC?
I don't know. I'm searching and I'm giving a notice.
Come at 2 o'clock.
2.
Both matters.
Both matters.
If I'll do Tani and you.
For item number 5, I'm for the state.
This is the item number 5, this is the affidavit of service.
Are you there for the corporation?
That's not, I have been,
All right.
the death certificate has not been produced. Death certificate issued, but another copy or paid for by the petitioner. One document or my attendant has not handed that the deputy chief, deputy CMHO, health department should have noticed that he directed to the petitioner to meet the office on 17th April 2020. Whether the petitioner has
Did the petitioner receive this communication?
Yes, I have received this in my mail. My petitioner is a 84 years aged person. He went there along with all the documents. They have said that no, since you have filed a writ petition, we have changed our mind. We will not give you the copy unless the order is passed. This is the email they have given to us.
Where is your application?
Well,
Application for grant of the duplicate death certificate?
well, it is my lord, page number 21 of my writ petition.
March 1999, the death was registered.
Registered.
And it is appearing from the
It is appearing-
official portal of the KMC.
Yes, KMC. It is
You want a duplicate?
Yes, my lord. Unless a certificate copy is there or the copy, original copy, we will not be able to file the probate case.
Please come. How are you related to this?
No, I am the friend. I am
Friend? Why will the friend require the death certificate?
no. He has given me a flat. He has 8 flats. I have invested some money against him for his treatment and other related purpose. For that reason, he has made me a will. I am in possession of that flat. He has given me a will.
Given me a will means who has executed will?
The one Mohit Kumar. His name is one Mohit Mohan Sinha.
The person who died is named Siddhartha Sinha.
Is the son of the Mohit Kumar Sinha, Mohit Mohan Sinha. Both are required.
1 minute. Mohit has died.
Mohit has died.
Siddhartha has also died.
Also died.
Right. Now
Siddhartha is predeceased. Siddhartha is predeceased to Mohit.
Very well. But now who intends to obtain the death certificate?
Madam Dilip Kumar Kaur, who has given the beneficiary of this will. Will I have annexed.
Will executed by?
Mohit? One Mohit Mohan Sinha.
Where is it?
Madam, it is the page number 13.
Oh. 2006. And he died. When did Mohit die?
Well, Madam, it is the next writ petition.
Give me the date.
Madam.
Have you not mentioned in this writ petition 2014?
(24/7, 2006 is the 28 December 2014.
the petitioner claims to be the beneficiary of a will executed by one Mohit Mohan Sinha, son of late Mohini Mohan Sinha. Stop. Paragraph, for the purpose of obtaining probate of the said will, the petitioner requires a certified copy of the death certificate of late Mohini Mohan Sinha and his son Mohit Mohan Sinha,
No, my lord.
who predeceased his father
Siddhartha
Mohini
Sinha.
Mohan. Oh,
Siddhartha.
sorry, Siddhartha Sinha. Siddhartha Sinha, who predeceased his father Mohit Mohan Sinha. কি বললাম ওখানে আরেকটা একটু বলুন তো? He requires the late Mohit Mohan Sinha and Siddhartha Sinha, son of Mohit Mohan Sinha, who predeceased his father. Stop. Application was made before the Kolkata Municipal Corporation on 1st March 2023. The same has not been replied by the authority. Stop. After filing, no, not filing, after service of a copy of the writ petition upon the respondent authorities, a communication over electronic mail was forwarded to the petitioner, intimating the petitioner to visit the office on any working day along with all documents in support of his submission. Stop. Next. Learned advocate representing the petitioner submits that the representative of the petitioner visited the office of the respondent authorities, but as the writ petition is pending, the authority did not entertain the petitioner. Stop. Next. Paragraph. The petitioner has annexed a copy of the death registration details as appearing in the official website of the Kolkata Municipal Corporation. Stop. It appears that the death of Siddhartha Sinha was registered with the corporation on 18th March 1999. Stop. It appears that the death was already registered in the records of the Kolkata Municipal Corporation, and the petitioner intends to obtain a certified copy of the same for proceeding with the probate of the last will of 4 weeks from the date of communication of this order. Stop. The petitioner shall be obliged to produce all necessary documents in support of his claim for issuance of death certificate. Stop. The writ petition stands disposed of. The email communication dated 16th May 2023. Not 16th, 18th May 2023. Be written with the records.
Any formality is required to obtaining certified copy that to comply.
Petitioner will also be obliged to comply the necessary formalities required for obtaining the certified copy of the death certificate.
And my client undertakes that he will comply. Six.
Is the death certificate annexed?
Is the death certificate of the testator?
Is it annexed?
No, it is not canvassing in the website because Bidhannagar Municipal Corporation is not canvassing.
When did the person die? 2006.
2014.
14. Was this area under the jurisdiction of the Bidhannagar Municipal Corporation all along?
All along.
Do you all have a web portal or something of that?
My lord, probably
Appeal
at
to
that
the
time it
case.
was not there, but now it is there. Now it is e-registration of birth and death is there.
And
Whether exactly on that date it was there or not, my lord, I'm not.
marks have not been updated.
My lord, probably not, my lord.
I've checked it, my lord.
Not there.
But our reason was only that no legal heirs came forward, my lord. In course of business, my lord, it creates complications. That is why, my lord.
I understand. This is the reason I wanted to see the will.
Yes, my lord, I have also gone through it while the other matter was, I checked the other petition also. But it appears that the deceased did not have any legal heirs. But, and whether the will is correct or not, I cannot,
Probate
for
proceedings.
this client, I cannot make any comments.
Please come. The petitioner claiming to be a beneficiary of a property left by one Mohit Mohan Sinha since deceased intends to obtain probate of the will executed by the said Mohit Mohan Sinha. Stop. For proceeding with the probate proceeding, the petitioner requires the certified copy of the death certificate of the testator. Stop. An application was made for issuance of the death certificate before the Bidhannagar Municipal Corporation in March 2023. Stop. The same is yet to be answered. Stop. Next. The present writ petition is accordingly disposed of by directing the
3, that's my number 3.
Joint Municipal Commissioner within bracket general permission and death and birth certificate, Bidhannagar Municipal Corporation, to take into consideration the prayer of the petitioner for issuance of death certificate of late Mohit Mohan Sinha. Stop. The aforesaid respondent shall afford an opportunity of hearing to the petitioner for production of necessary documents in support of his claim. A reasoned order shall be passed and communicated to the petitioner at the earliest, but positively within a period of 4 weeks from the date of communication of this order. Make it 6 weeks.
Well, that
6 weeks.
necessary formality as Mr. Panda suggested.
6. Next, the petitioner shall be obliged to comply with all the necessary formalities required for obtaining the death certificate disposed.
Wait, my lord, I am appearing for the state. My lord. All right, now we check on action.
Right.
9
Here you pass over. Call the next matter.
I am appearing on behalf of the state respondent.
Who is the answering respondent?
The answering respondent is the state, but your lordship direction was to take the Union of India as part of the respondent.
Why?
That's why, my lord, this is the scheme of the Union of India. Page 28, your lordship can have. Page 28. He has been appointed long back, but it has not been confirmed.
Is the state ready with instructions?
My lord, in the earlier occasion, I have submitted a report that is in lordship's file.
Employee of the central government. That means you are funding it. You are financing everything, but that apart, you do not take any responsibility. Point number 4. The DLB has instructed that he was appointed by the Directorate of Health Services, but his confirmation was denied. Why is it so?
Confirmation was given, we have received it long back, and thereafter one after another one letter was given. Last letter we received 2013. This is director addressed to the director of local body by the municipal authority.
Is there any order denying his confirmation?
But till date it has not been confirmed.
No denial also.
Whatever it may be, that's why your lordship intended to take instruction. What is it?
No, he has taken.
They submitted the scheme of the central.
Yes.
If it is the funding of the central government, but a confirmation is required to be by the state authority.
Right.
So let them confirm it.
Show me your appointment once.
Page 26 and 27, you also can. Page 26 and 27.
Temporarily appointed as family planning welfare, 1996, and he is still continuing.
And the confirmation clause 2, confirmation of the service under the above said schemes may be made after 1 year of satisfactory service. The same decisions of page 27. I've got the document that the data addressed to the director of local.
Who pays your salary now? Do you get a regular scale of pay? No.
Thank you, Lord. So very well. I could not contact receiving the salary, whether it is regular or
Huh.
that I can't say.
Okay. Still now you could not obtain instruction.
That's my mistake. I could not contact. Anyhow, the letter is clear. The chairman's respective of this letter is clear. Following the recruitment rule, the advertisement was there, selection was there, not the backdoor entry. Everything was.
Please come. The petitioner was temporarily appointed as family planning welfare worker by the chairman North Damdam municipality.
Family planning welfare worker and another petitioner number who is the storekeeper come clerk come account.
Two
petitioners.
Why in one writ petition? Why in one writ petition? Two separate causes of action.
Because of the fact, my lord, the letter page 28.
28.
See the independent Chakraborty and Kuntal Prokai that is mentioned by the address to the director of local.
So what? Cause of action is completely separate to individual persons.
Some of their appointment letters, they are
Two appointment letters,
two appointment letters.
two different identities, two different individuals.
For the confirmations.
No, this is not done. How can two? They both will be receiving separate salary.
I can hold the court fees.
No, not court fees is not very important. 200 rupees court fee you will pay. It hardly matters. But the thing is,
What I have advised, because of the fact the losses can have been test
I have seen that.
and the prayer submitted by Mr. Chakraborty and Mr. Kuntal for absolution of the case of the staff. So, the one letter they have prayed for the and a confirmation of the service before the director of local. They are treated together.
And that will be treated as a cause of action to be.
And the appointment letter issued by your lordship can be seen. The appointment letter issued on the
Same date, same contents, two different individuals. Salary is different. Benefits will be different, enjoyed by both.
Confirmation of the service.
Confirmation only one in that case.
Shut the door, your lordship are undertaken to pay the court fees. Here.
The petitioner number 1 was temporarily appointed. Not them, the municipality. By letter of appointment dated 10th August 1996 on the recommendation of the selection committee appointed by the Director of Health Services, Family Welfare Bureau under Family Planning and Welfare Scheme sponsored by the Government of India on certain terms and conditions. Stop. Similarly, the petitioner number 2 was appointed as storekeeper, clerk, accountant on the same date and in the same manner as that of the petitioner number 1. Paragraph. As per the letter of appointment, the service of the petitioners is not a municipal service, but an employment under family planning and welfare scheme sponsored by the central government of India. Stop. Confirmation of service under the scheme may be made after 1 year of satisfactory service. The state government service rules was applicable to the petitioners subject to entitlement of the scale of pay. Stop. The grievance of the petitioners is that till date, their service has not been confirmed by the state government. Stop. Next. By a communication dated 11th February 2013, the chairman, North Damdam Municipality, forwarded the prayer of the petitioners seeking confirmation to the Director of Local Bodies. Stop. In the said request letter, the chairman specifically mentioned that as per the order of the Deputy Director of Health Services / Government of West Bengal, dated 5th December 1995, the municipality published notices inviting applications from eligible candidates. Stop. 19 applications for the post of officers and staff were forwarded to the Deputy Director of Health Services for arranging interview and preparation of panel list. Paragraph. 4 selection committee was formed by the State Family Welfare Office, and the said committee prepared the panel for both the posts. Stop. The panel was forwarded for issuing letters of appointment to the selected candidates. Stop. It has been admitted that the petitioners were selected in their respective posts and they joined service in the month of August 1996. Stop. The petitioners requested the municipality to take up the issue, and accordingly the municipality forwarded the request of the petitioners to the Director of Local Bodies. Stop. Further representation was also filed on behalf of the petitioners before the Director of Local Bodies in November 2021, but the same has not been answered. Stop. Next. The petitioner prays for a direction of confirmation of their service. Learned advocate representing the Director of Local Bodies and ex officio Joint Secretary to the Government of West Bengal, Urban Development and Municipal Affairs Department, has forwarded instruction to the learned advocate mentioning that the service of the petitioner is not municipal service and he was an employee under the Family Planning and Welfare Scheme of the Central Government of India. Stop. He was appointed by the Directorate of Health Service Stop. The specific contention is that the Joint Director of Health Service specific contention is that the staff under the Family Planning and the Welfare Scheme are not considered as government employee, and hence the question of confirmation does not arise. Stop. Next. Learned advocate representing the Union of India relies upon the appointment letter issued in favor of the petitioners, wherein it has been clearly mentioned that the state government service rules will be applicable. Stop. Next. It has been contended that apart from funding the scheme, the Union of India does not have any responsibility in respect of the employees under the said scheme. Stop. Next. Upon hearing the submissions made on behalf of the parties and upon perusal of the documents placed before this court, it is evidently clear that the state government ought to take the responsibility of the petitioners who were appointed under the recommendation of the Director of Health Services, Family Welfare Bureau. Stop. Next. The scheme in question may be funded by the central government, but that does not imply that the employees or under the scheme will be the employees under the central government. Stop. The letter of appointment clearly mentions regarding the confirmation of service under this scheme after 1 year of satisfactory service. Stop. By this time, the petitioners have already put in more than 25 years of service in the municipality. Stop. The period within which confirmation of service ought to have been made is 1 year from the date of appointment. Stop. The said period is long over. Stop. It is high time that the state government takes a decision with regard to the prayer of the petitioners for confirmation in service. Stop. Next. The state government cannot disown their responsibility and liability to confirm the service of the petitioners. Stop. Next. In view of the above, the instant writ petition is disposed of by directing the Director of Local Bodies to take immediate steps for consideration of the prayer of the petitioners for confirmation in service in accordance with the relevant scheme and in terms of the letter of appointment issued in their favor. Stop. If required, the Director of Local Bodies shall afford an opportunity of hearing to the petitioners, the municipality, and all other necessary parties prior to taking a decision in the matter. Stop. A decision shall be taken and shall be taken within a period of 12 weeks from the date of communication of this order, and the reasoned order passed shall be communicated to the petitioners immediately thereafter. Stop. Next. Learned advocate for the petitioners is directed to forward copy of the appointment letter, the recommendation made by the North Damdam municipality on 11th February 2013, and the representation filed before the Director of Local Bodies in November 2021 to the aforesaid respondent at the time of communicating the order of the court. Stop. Next. The writ petition stands disposed. And the present writ petition has been filed by 2 petitioners by depositing only 1 court fees. Stop. Learned advocate on record of the petitioners is directed to deposit the deficit court fees in respect of 1 petitioner in the course of the day. Affidavit of service taken on record.
ষোলো নম্বরটা 16 থেকে হয়ে যাচ্ছে 17 আসছে 17 আসবে
I'll hear. Please wait. Let the list be called.
Yes, ma'am. I am for the state responder.
State? You are for the petitioner? On the prayer of the learned advocate representing the petitioner, list the matter after the ensuing summer vacation. Record the appearance of the state.
My lord, I am for the petitioner, my lord. My lord, for the state, Kolkata Municipal Corporation 6 time to file the report today. My lord,
Who are you to make submission on behalf of the Kolkata Municipal Corporation?
no, my lord, I am not.
Yes.
Led by Mr. Subramanian. This is the instruction, ma'am.
Let me see. Anybody representing the private respondents?
My lord, I'm responding the private respondents. There are specific prayers that I have, but if your lordship gives me the permission to go ahead
Yes,
with this.
certainly.
My lord, this writ petition is not maintainable either in terms of facts or in law. This is filed with ulterior motives just to use the powers of this honorable High Court to as a weapon to satisfy their personal vendetta and ego. I'll tell you the reasons why exactly inspires me to do this submission. There was no urgency to seek Article 226. My lord, if you go to the list of dates, you would see that the date last mentioned was the complaint given to the KMC on 14th of March. Just after 3 days, this writ petition was filed. What is the urgency? The pseudo urgency was created on the ground by misrepresenting facts that there was an ongoing construction, which is not correct. There is no ongoing constructions. There is no erection of new towers or any further towers ever. Everything that happened has already happened. I'll give you the correct that.
But the things which already happened, did it happen in a legal manner?
That is not the question.
It's
It
written
is
over there. That is not written over there.
not written over where? In my, this is my personal handout notes.
Right.
So now this is, there is a specific way of regularizing if anything has, if there is any infringements.
Something different. How did you construct it without obtaining a sanction? You tell me first.
There was a sanction. We are paying taxes to the KMC, and also that there are
Hardly matters whether you pay tax in respect of a construction that has been made illegally or not. Thing is, whether you could have made a construction without obtaining any sanction. Not there in the handout.
The way to get it done is to be doing through regularization procedures are there, but for that 226 requires not to be invoked in this manner.
The petitioner complains of illegal and unauthorized construction at the behest of the private respondents in premises number Z3-41/1, Dr. A.K. Road, Ward number 141, Borough 15, under jurisdiction of the Kolkata Municipal Corporation. Stop. Learned advocate representing the private respondents submits that the construction in question was made long ago. Stop. There is a procedure for regularizing any unauthorized construction that has been made. And at present, no construction is being carried out. Stop. The petitioner ought not to have approached this court by invoking the writ jurisdiction. Stop. Next. Learned advocate representing the Kolkata Municipal Corporation has filed a report signed by the assistant engineer within brackets civil/building/Borough 15 and the executive engineer within brackets civil/building/Borough 15 on 15th May 2023. Stop. It appears therefrom that on receiving the complaint, departmental inspection was carried out at the subject premises. Stop. During inspection, it revealed that an occupied old 5-storied building stand at the subject premises. Stop. The building was constructed in accordance with the plan sanctioned in the year 2011. But there has been deviation in construction that has been made. Stop. The persons responsible installed telecommunication towers over the 4th floor roof level. Stop. The engineers of the corporation have prepared the demolition sketch and the infringement statement to process the case under section 400 of the KMC Act 1980. Stop. Upon hearing the submissions made on behalf of all the parties and upon perusal of the instruction forwarded by the engineers of the Kolkata Municipal Corporation, it appears that unauthorized construction has indeed been detected. Stop. Next. Accordingly, the executive engineer within bracket civil/building Borough 15 is directed to take prompt necessary steps to deal with such unauthorized construction in accordance with law at the earliest, but positively within a period of 12 weeks from the date of communication of this order. An opportunity of hearing shall be given to all the necessary parties prior to passing a final order in the matter. Stop. The reasoned order shall be passed and communicated to all the parties. Writ petition disposed. Affidavit of service taken on record. Did you file your wakalatnama?
Yes.
Where?
It's already filed.
Have you checked up yourself? Do you know how to check it?
We checked up. Yes, it is checked.
How do you check it?
We checked it online. We have. Yeah, it has been checked online, Yarman.
It has been checked.
Yes. Much obliged.
Item number 19, my lord. In this case, I am appearing on behalf of the petitioner. On the last occasion, my lord has directed to take inspection in regard to the heritage, which part of building has been declared as heritage. My lord has given a direction to the Kolkata Municipal Corporation to take inspection and filed a report to that effect, my lord.
In the building, here is the report.
Which grade?
Grade 2B.
2B.
And actually, petitioner has been repeatedly, we asked the petitioner to take the permission from the heritage and thereafter go for construction. Actually, we actually served a notice under 411(1). And in the grab of that, he's actually constructing. So we issued 401 stop of work notice. And thereafter, the petitioner came.
No, but then if you have issued 411(1), that means the building is in a ruinous state.
That is for there is certain dangerous portion may fall down. Okay, that does not actually authorize the petitioner for going for construction. The nature of construction when that building is declared heritage. So you also kindly see the report. You kindly. My lord, he has given the here that is inspection at the time of inspection.
He was there. And that is all right. So what is to be done now?
Kindly, my lord, this necessary order may kindly be passed so that I can make permission from the Heritage Commission, and I will make the without changing the nature and character, I will do the repairing. But I know, my lord, if there is a permission is required. Kindly dispose of with this order, my lord. I will take permission.
My lord,
second order of this,
my lord,
this honorable court and do the repairing work. And I will do the repairing work in presence of the civil engineer. I am not standing on the way without changing any nature.
You cannot stand in the way. It's not a matter of I'm not standing,
Yes,
and then you cannot stand.
In regard to the nature is concerned, I will not change the nature and construction of my property.
Pursuant to the direction passed by this court on 25th of April 2023, a spot inspection was conducted in the presence of the parties. Stop. The property in question is enlisted in the list of heritage maintained by the Kolkata Municipal Corporation, Environment and Heritage Department under grade Roman 2 caps B. Stop. As portions of the building became ruinous, corporation issued notice under section 411 within bracket 1 of the KMC Act and also affixed a caution board under section 411 within bracket 2 of the KMC Act. Stop. Paragraph. As the petitioner, in the garb of demolishing the ruinous portion, started making construction without obtaining any sanction from the corporation, a stop work notice was issued. Stop. The petitioner has since been made aware that a permission is required to be obtained prior to starting repairing / construction in the subject premises. Stop. The petitioner undertakes to obtain permission prior to making any further construction work. Stop. The petitioner also undertakes that the construction / repairing work will be done under strict supervision of the empaneled structural engineer with no objection obtained from the Environment and Heritage Department of the KMC. Stop. Next. In view of the undertaking given by the petitioner that construction will be made after obtaining necessary permission from the respective authorities, the writ petition accordingly stands disposed of. Next, the report filed by the assistant engineer within brackets civil and executive engineer within brackets civil, building department, Borough 1, KMC, signed on 11th May 2023, be retained with the records.
No 402 board has been affixed in my property, and there is no board in regard.
There is a mention that a board has been
No,
affixed.
there is no board. Now, I have confirmed, my lord, there is no board in regard to 402 is concerned. I'm totally sure.
I do not know, but then you obtain permission and do your work.
Kindly
There
make
is
it
a
clear that
difficulty.
I'm that part that 402 board
अच्छा,
is
একটা জিনিস লিখে নিন। Learned advocate for the petitioner denies that any caution board under section 411 within bracket 2 of the KMC Act 1980 has been affixed to the subject premises.
Read, I'm really grateful.
I beg to appear for the state response.
Give your appearance, please.
My lord, I am for the private respondent. Before starting my
for the petitioner.
friend, this matter, I think, become infractious because the authority special officer already passed the demolition.
Let me make my submission. On the last occasion, Lordship directed that I should serve the KMC again. I have served.
This is the copy of the order.
affidavit of service.
May I hand up?
And Lordship, Lordship may kindly see the demolition, that order by the special officer. It notes that there is a deviation and major deviations, Part A, Part B, and Part C. This order has been passed on 15th February 2023. I think that is what has been handed up.
Yes.
Yes, yes.
But till corporation has not complied with the order of their special officer even, that does not make the writ petition infructuous.
Kindly have a look.
And there was,
I'll see, please wait, please wait.
and there,
What my learned senior friend submitted.
I'll hear, please wait.
and no appeal has been preferred.
Appeal will be preferred if the person responsible is aggrieved. If
Is not
nobody is
aggrieved.
aggrieved,
And-
appeal will not be preferred.
Yes, and therefore the municipality should carry out.
What is your prayer?
Yes, kindly come to page 11. Starts from 10. Page 10 of the writ application.
Yes, you want demolition, you want implementation.
Yes. That has been already passed.
So now that
Steps
order has
have
to
been-
be implemented.
A fresh petition has to come. Please come.
Deeply obliged, Your Lordship. Grateful to
The
you.
petitioner
I'll file it tomorrow.
for
Implementation of this order, for this implementation. But how does it save the private respondent that he is becoming so joyous?
the petitioner complaints of illegal and unauthorized construction Act. KMC premises number 109, Shagor Manna Road, within bracket P-115, Shagor Manna Road, Post Office Pornosri, Ward number 132, Kolkata 700060. Stop. Next.
In fact, my lord, I will just interrupt for a minute. There's a criminal proceedings also started.
401A possibly.
401. If I may hand up that also.
No use. That is a different forum you have to follow.
Absolutely.
Learned advocate representing the petitioner as well as the private respondents admits that the special officer within bracket building has passed an order on 15th February 2023
After the writ petition had been filed.
wherein interim order has been passed for demolition of the unauthorized portions. Stop. Next. Learned advocate for the petitioner submits that as unauthorized construction has been directed to be demolished, accordingly, necessary order be passed for implementing the order passed by the special officer within bracket building. Stop. Next. I am afraid that the prayer of the petitioner for implementation of the order of the special officer cannot be entertained in the present writ petition. Stop. Next. The cause of action at the time of filing of the writ petition and the cause of action on account of passing the order of demolition by the special officer building being different, the prayers made in the writ petition cannot be made applicable at this stage. Stop. Next. The writ petition accordingly stands disposed of. Stop. It will be open for the petitioner to seek implementation of the order passed by the special officer building in accordance with law, if so advised.
Deeply obliged.
Affidavit
Grateful
of
to you.
service taken on record. Copy of the order passed by the special officer building be also retained with the records.
Grateful to you, Lordship.
My lord, item number 21, learned advocate Arunabh Ganguly is for the petitioner. He is engaged on courtroom number 7. I am praying for not today.
Not today,
Not today.
prior to the vacation.
After vacation. My lord.
Just imagine what to say. What is the matter about?
Actually, I am unaware about that.
Seeking water connection.
And they want after vacation. What is your instruction?
The corporation is ready to give connection only, going to the premises of the petitioner to give water connection. But one civil court order has been handed over to the corporation people. In that
Civil court restraining?
Yes, no, not restraining. The petitioner approached the civil court and made 2 applications. One for erecting or construction of a privy and another for water connection. Privy has been allowed, but without water connection.
On the prayer of the learned advocate representing the petitioner, let the matter appear in the list after the ensuing summer vacation.
I wish to appear on behalf of the Dubrajpur municipality.
I am for the state respondent led by Mr. Supriyo Chattopadhyay.
Lord, I appear for the petitioner.
Yes.
Lord, the petitioner was appointed, Lord, as Shishu Shikha Sahayika under the said municipality. Lord, the petitioner was appointed in the year of 2002.
2002.
At the time of appointment, my lord, there was year-to-year renewal. Subsequently, in the year of 2016, an order was passed, my lord. On that basis, upper age limit has been fixed up to 65 years. And my lord, 65 years, and the municipality, in the meantime, saying that they were not aware of that order, and that's why they have disengaged.
They have disengaged.
And subsequently,
When was the disengagement made?
Disengagement made, my lord, because of they attained the 60 years of age.
Oh, 60.
Yes, 60 years of age.
Hmm.
And my lord, by the order of the Honorable Court, my lord, they have been re-engaged. And in that court, the municipality admitted, your lordship may kindly have a look, the report of the DLV that is admitted, my lord, page 37, relevant page is my lord, page 38.
Yes.
Page 38. Paragraph, my lord, after the
Is this the impugned order? No, this is a report.
This is the report.
Relying on which the writ petition was disposed of.
That writ petition was disposed of, and my
Yes.
lord, liberty has been granted to file appropriate representation before the appropriate forum for, my lord, damages seeking whatever remedies, my lord. And my lord, my humble submission before your lordship that for that period of time, the state government sanctioned the fund. Dubrajpur municipality received the said fund. They have neither really funded to the state government. They have utilized the said fund.
Utilized.
That's it is, my lord. Neither they in my favor, nor refunded to the state exchequer.
All right.
What they did.
Oh, will you be happy if the money is refunded back? How many months?
My lord, months.
Yes.
1 year.
1 year.
Approximately 1 year.
And admittedly, you did not work because you were disengaged.
Yes, disengaged, and disengaged means they have admitted that has been wrongly done. Admitted. It is admitted.
How much is the honorarium?
10,000 per month. 10,000 per month.
Yes.
Well, earlier the petition, there is a direction to the petitioner to approach the appropriate court where this is the damage. The writ court cannot, my lord. The earlier writ petition, the honorable court consciously, my lord, directed the petitioner to approach the appropriate
Which
forum
page?
and
Which
page,
page?
my lord, 29.
29.
29. My page, my petition copy 26, 29.
Achha, 29. There
This
are two
court also
paginations.
takes, my lord, got it?
Hmm.
This court also takes note the unjust treatment that was meted out to the petitioners with regard to the compensation for the period when the petitioners were not working and were wrongly disengaged. The petitioners would be at liberty to approach the appropriate forum. Because
I
the
have
writ
made
court
the
is not,
representation
my
to the
lord, the
municipal authority.
appropriate forum because
Since
it
they
is
have
a
received
question
the
of facts, how many days they did not work or which fault that should be, my lord, agitated before the appropriate forum. There is the order passed in the earlier writ petition. Again, the petitioner approached this honorable court for payment of the salary for that period.
For how many years or for how many months did you disengage the petitioner?
My lord, at that point of time, no order was, my lord, before the municipality. That's why.
Give me the period during which the petitioner was out of service.
My lord,
My lord,
the
date
petitioner,
of
petitioner
termination.
Must be having the documents. Don't you have the documents?
when they attain the age of 60 years, we
Disengage them. And then when you reinstated them?
after 1 year.
So 1 year, 12 months. Did you receive the money from the government?
My lord, the money which was allotted to the fund that was received. That was received or not received, that is, I have to take instruction, my lord.
Now, the state government says that it has been received by you.
Instructions
that has been dispersed to the.
Disbursed, but we did not want to utilize the fund because there are
No, utilization is separate.
Yeah.
It has been disbursed, credited to your account.
Yes.
Credited to your account. So what did you do with this one year's salary of the honorarium of the employee?
Well, I have to take instruction because there is a financial account. Accounts will speak. The money where go. And I have to take instruction, madam.
Very well, please come. The grievance of the petitioner is that the period during which the petitioner remained disengaged by the municipality the payment in respect of the petitioner was allotted by the state to the municipality. Stop. The municipality neither released the payment in favor of the petitioner nor refunded the money back to the state government. Stop. Next. The petitioner remained out of service from 31st January 2021 to 1st February 2022.
Yes.
Stop. The court in the earlier round of litigation
It's 20.
clearly recorded that the petitioner was treated in an unjust manner. The court was pleased to set aside the order of disengagement / termination of service of the petitioner on attaining 60 years of age, as the petitioner was entitled to work up to 65 years. Stop. Next. Learned advocate representing the state respondent submits upon instruction that money was duly allotted to the municipality for the period during which the petitioner was out of service. Stop. Learned advocate appearing for the municipality seeks time to take instruction and report before this court as to whether the money allotted in favor of the petitioner was at all utilized or not. Stop. Next. Let a report be filed by the municipality mentioning as to whether the amount received from the state respondents on account of the honorarium of the petitioner for the period 31st January 2021 to 1st February 2022 has been utilized or not. Stop. The report shall also specifically mention whether the said amount was refunded to the state government or not. The report shall also specify whether the money is being held over by the municipality. Let the report be prepared and served upon the learned advocate representing the petitioner and the state respondents by 16th June 2023. Returnable matter is made returnable on 27th of June 2023, marked for orders Shatash. The petitioner will be entitled to file an exception to the report filed by the petitioner prior to the next date of hearing.
I'm grateful to you. Subject to lordship sanction matter to appear on
June 27.
27. 23.
Next matter, same.
Same period is different, my lord. Date of termination, my lord, 31st May 2019, and my lord, re-engagement same date, 1st February 2020.
এখানে দুটো ডেট দিয়েছিলাম, এখানে ডেটটা হবে 31st May 2019 to 1st February 2020. There was an earlier writ petition in this matter also.
Yes.
And who is for the state?
My lord, I am appearing on.
What is your instruction?
My lord, I am appearing on behalf, item number 23, my lord. Just.
What is your instruction?
Yes, my lord. My lord, kindly.
Was money paid to the municipality?
Yes, my lord, kindly come to page 12. 50.
Just tell me, was money paid or not?
My lord, DLB, Director of Local Bodies, already, my lord, granted the amount in favor of the municipality, and it is the municipality to decide whether the petitioner are entitled or not.
Very well. Same, absolutely same.
আমরা ওটাকে ফেরত দিয়েছি কিনা সেটা জানতে চেয়েছি, বুঝলে?
Report filed by such and such be written with the records.
আমরা কাজ করিনি, কি করলাম, ফেরত দিয়েছি কিনা সেটা জানতে চেয়েছি। সেটা রিপোর্ট ফাইল করতে বলেছি, আমরা করে দেবো। আমি মিউনিসিপ্যালিটি।
Does the state respondent take note of the fact whether the money that is allotted to the municipality
Yes,
is properly
yes.
utilized or not?
No, that cannot be ascertained. Only money allotted in favor of the municipality, whether it is specific instruction, written instruction, whether it is the municipality to decide whether petitioner is entitled to get that period money or not.
My specific query of the
No,
court
madam.
is, if money is allotted for a particular purpose, do you take note of as to whether the money was actually utilized or not? If the money is not utilized, what will happen?
Yes, my lord.
Money is
Yes.
disbursed in favor of
77.
X.
Actually, my lord, there are 77 numbers of, my lord, the Shohika. It was allotted in favor of.
You are the mighty state. Try to understand.
I have to
77 is no factor. There are so many employees. Some Mr. X, the amount was supposed to be paid. It is not paid. What happens to the money? The municipality utilize it for somebody else?
No, certainly not. It
What?
will be revert back to the, my lord, DLB.
Do you keep a track as to whether it has been received by the employee, whether it has returned or not?
No, my lord.
No, the money gets siphoned to somebody else.
I think not, my lord.
I think no.
Because, my lord, it is in the head, a particular head. It was in particular
Head, there are so many heads that nobody knows where the money goes. Anyway, call the next matter.
Municipality file করবেন?
হ্যাঁ, আমি ইনস্ট্রাকশন নিয়ে নি কি করেছে টাকাটা।
আচ্ছা, ঠিক আছে।
আমাকে একটা কপি দাও না, তাহলে আমি মিউনিসিপ্যালিটিকে বলতে পারি যে ডিএলবি রিপোর্ট দিয়েছে। হ্যাঁ,
ইনস্ট্রাকশনটা
Who is there for the petitioner?
My lord, 24, my lord, Mr. Mustafa for the petitioner, my lord, I appearing led by Mr. Mustafa. Today, my lord, report we called for, my lord. Last occasion.
I've got the report, my lord.
What is your prayer?
My lord, report be handed over and.
Report is different. What is the prayer in the writ petition?
My lord, kindly short pass over, my lord, Mr. Mustafa is code number 5, my lord. Kindly make it short pass over, my lord.
The fact is this, my lord.
Yes, fact is
My lord,
spot inspection conducted.
unauthorized construction, there no floor deviation, but there is একটা floor আছে. Oh, floor is there and no deviation, maximum deviation. But I've become mechanical.
We have already submitted, my lord.
Sanction area, deviation area same.
Sanction area, deviated area, same. What have you done? Huh?
Second page is the detailed measurements.
Not it is that, my lord, without sanction is there.
Sanction is there for 802 square feet. And you have constructed similar area without the sanction. Demolish it.
I have made a estimate plan, let both the be considered, their fair as well as my estimate plan, because the municipal authority have the power to regulate.
And you also have the power to make construction without a sanction plan. Then
There is a
regularization comes later on. Isn't it? Why will you make construction without a sanction plan?
not a commercial.
Maybe residential. Does it absolve you of the responsibility to obtain a sanction plan prior to making construction? It isn't so, isn't it? Then please come.
Additional floor.
Inspection report has been filed by the Howrah Municipal Corporation.
Exception file.
Stop. It appears therefrom that there has been a massive deviation and unauthorized construction made at both the premises, that is 82 and 82/1 Kovi's Ghat Road. Stop. In the premises number 82, the unauthorized constructed area is approximately
A short leave, madam.
2664 square feet. And in premises number 82/1, the unauthorized portion is approximately 2785 square feet. Stop. Next. Learned advocate for the private respondent submits that an as-made plan has been filed before the Howrah Municipal Corporation seeking regularization of the construction made. Stop. The instant writ petition is disposed of by directing the Municipal Commissioner, Howrah Municipal Corporation, or his delegate to take necessary steps to deal with the unauthorized construction in accordance with law after giving reasonable opportunity of hearing to all the necessary parties. Stop. A decision shall be taken in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Writ petition stands disposed of. Inspection report filed by the Howrah Municipal Corporation be written with the records. It is not your petition.
For the petition. Item number 25, I am appearing on the private respondents fund. In this matter, my lord, the petitioner is not getting water, my lord. Lordship directed the the petitioner should repair the pipeline, taking help of a licensed plumber, and the private respondent should not object to that. That was the direction, my lord. Accordingly, my lord, we have paid the required the amount, the fees that is required to be paid, my lord. The plumber came, my lord. The difficulty is, my lord, there are two gates in these premises. One gate is kept under lock and key by the private respondent. Through that gate, the main pipeline comes to that gate. The pipeline enters the premises. They are insisting that you make a fresh layout and take the pipeline through the other gate. So that will incur a huge cost and it will disturb the total layout. And the water flow will also not be proper as I have been as my client has been instructed by the plumber.
My lord, the only thing which is required, my lord, if the gate is unlocked by the private respondents, my lord, then the pipeline can be repaired, my lord. My lord, yes, which is beneath the ground, my lord. It will be repaired and we will restore whatever the condition is. We shall restore it. And if it is done, my lord, even the private respondent will get the water. Not only the petitioner, the premises will whoever is residing there, my lord, will get the water. But the KMC authorities came. They have checked the pipeline outside the premises, the public pipe, water supply is ready there. Only the inside the premises, it has to be repaired, and the pipeline can be it can be made. The commission can be made up through the both the pipelines has to be joined. For that, my lord, the lock has to be reopened. My lord, my instruction is that the private respondent is insisting that to relocate the layout of the pipeline. Well, that is very difficult, my lord.
But actually, in the building, my lord, there are two entry, my lord. One led to the room of the petitioner, my lord, and other entry led to the, my lord, private respondent, my lord. My lord, the KMC earlier has visited the place, my lord. Now, from their, my lord, suggestion, the entry which led to the room of the petitioner, that is the, my lord, shortest possible way, my lord. And the private respondent last occasion, pursuant to your lordship's direction, my lord, as per my instruction, my lord, no plumber from the concerned, my lord, department has visited the place, my lord. My lord, we have no objection against the, my lord, water connection to the room of the petitioners. My lord, our contention is, my lord, the water line may be installed through their portions, my lord. My lord, may call for a report from the KMC, my lord. It will, my lord, crystal clear, because earlier occasion KMC has suggested that yes, the water line can be installed through the gates of the petitioner itself, my lord. That is the.
Are you getting water? No.
Oh, my lord.
You are not. If the petitioner repairs the pipeline, you will also get water. Why are you adopting this dog in the manger policy?
My lord, actually, there is a
There
background.
is no actually. Don't go to the background. Look at front. Whatever is there in the past, forget it. Your client will also require water. The petitioner is ready to incur the charges. He will repair all what is done at the time of repairing the pipeline. And then he will also enjoy water, you also enjoy water. What is the difficulty? You'll open the gate, work will be done, it will be over.
My lord, later report may be called from
For what
KMC,
purpose?
whether the contention advanced by the petitioner, that is true or false, my lord.
I will take your contention to be true. I do not take the petitioner's contention to be true. I say whatever he is submitting is all false, all incorrect. I will take your submission to be true. Have you followed?
My lord.
There is already an existing connection which is defunct.
My lord.
Let it be repaired. Both of you enjoy water. Whatever the fight you'll have, go fight yourselves before the appropriate forum, but then drink water and then fight.
Then, my lord, let them to repair all the.
They will repair it. The court is here to take care of your problem.
My lord.
The learned advocate representing the petitioner submits that as the private respondent is not giving access to the licensed plumber for laying the pipeline, accordingly, the pipeline which is required to be changed cannot be repaired. Stop. Next. Prayer has been made for passing a direction upon the private respondent to open the gate so that necessary repairing work can be conducted. Stop. The petitioner undertakes to repair all the damages that may be caused at the time of laying the pipeline. Next. Learned advocate representing the private respondent submits upon instruction that the entry through the petitioner's portion will be the shortest possible way for laying the pipeline. Stop. Next. Be that as it may, as it appears that the defunct pipeline enters through the gate which is under the control of the private respondent. Accordingly, the private respondent is directed to give access to the licensed plumber of the corporation for the purpose of changing the defunct pipeline. Stop. The petitioner shall be liable to repair all damages caused at the time of laying the pipeline. Stop. The private respondent will also be entitled to enjoy water from the pipeline that will be laid after repairing the existing line. Stop. Let the matter appear in the list once again. On 19th of June 2023, marked for orders. You will also get water that is mentioned. So the petitioner cannot stand in the way that as payment has been made by him, he will get the water and he will not. So you'll get water for free.
$25.
26.
26.
26, I am for the private respondent.
You are for
26,
the-
I am for the
I'm for the
petitioner.
private respondent.
I am for the petitioner.
Yes.
Your Lordship, on 29th March, Your Lordship had passed an order directing the Kolkata Municipal Corporation to submit a report. They have not complied, my lord, the order. Neither they have served us so that we can file exception. There was a timeline which was given to the Kolkata Municipal Corporation to give a
Who is
report.
appearing?
Nobody is appearing for the Kolkata Municipal.
Who is appearing?
On last occasion, Pialis and Gupta was appearing.
He is possibly absent
What
today.
it happens, my lord, one thing
Kindly
also is
explain-
kindly to see the writ petition paragraph 3. Now they have particularly claimed that he is the owner of 1 kata 11 paragraph 3 of the writ petition. They have specifically asserted in this writ petition that they are the owners of the 1 kata 11 chataks of
For the
more.
Kolkata
Can
Municipal.
you excuse me, my senior is ill, he has not come to court today. And pursuant to my lord's last direction, my lord, a report was supposed to be brought. I was just talking, my lord, to the executive engineer, my lord, because of dearth of people, my lord, they could not send it. Kindly take it any other day.
Any other day means not today will do. Tomorrow can be done. Tomorrow-
My lord, I have asked them to send it by the WhatsApp even.
Yes.
If then, my lord, I shall get a downloaded copy from WhatsApp and I shall hand it over to.
My lord, in that case, my lord, I have to file an exception. I was given the
Let us
option.
see what comes in the report. How do you know you are required to file an exception on the basis of the report? The matter
My
can be
lord,
disposed of.
my lord has given an order
lord,
that they will serve us. And the second page, my lord had said a copy of the
lord,
report
what
shall
if-
be prepared and served upon the learned advocate appearing for the petitioner as well as the private. And exception, if any, may be filed by 4th May.
My lord, I am submitting one thing, my lord. In this self-same issue, a civil suit has been filed before the city civil court. Your lordship is kindly to see
What is
page,
the issue?
page number 97. Your
What is the
lordship,
issue before the
issue is
civil?
regarding the illegal construction.
How can illegal construction be decided by the civil court?
Now, what it happens, they have got an ex parte identity order. Now, I have filed an application under section 39(4). That has been contested and rejected, their pair. Now, your lordship is kindly to see page 97 of the order of this city civil courts, page 97.
I am only making it not today. Let
Now,
us see what the report
challenging
comes.
that order, they have filed division bench appeal. FMT is pending.
Let the FFT remain pending.
Not, my lord, not today.
Only not today.
Grateful, my lord.
May it please your lordship. Lord, I'm for the petition.
I'm for the respondent number 5. My last occasion I could not appear. I was at Kalipur. I talked to my junior. She was also busy at court number 4. Sorry, my lord.
Lordship will kindly see the last order, my lord, on 21st April 2023.
Are you aware as to whether the construction has been?
Last day, on 6th February 2023, I have filed by instruction with along with 2 photographs, 2 copy of photographs. Then my last occasion, 21st April 2023, I have submitted before lordship my instruction along with all photographs. And that photographs you will find out, my lord, that construction already G+5. Now they are making another submission that there is no G+5, there is only G+1. And my instruction along with the photographs, there is a date mentioned, 13th April and 4th January. Lordship, I have copied. May I submit before Lordship the copies of those photographs?
No, the photographs are here, I can see.
Lordship, this is the fresh copy and comparing 4th January and 21st April.
Don't show, wait. The document is here.
All copies are there.
Inspection is there. It says G+5 story building. Where is the demolition?
And my lord, the shocking part is
The portion which has been demolished, photographs have been.
The entire building is unauthorized.
Entire building unauthorized.
Entire building is unauthorized. No, the building is standing.
Standing.
Where is the private respondent? Yes.
my lord, we had instructions that the building was demolished at the now at this point of time, what is the condition? We don't know. We'll have to take instructions.
When were you instructed last?
Last on the first order, your lordship would find that it was mentioned.
my lord,
that it was,
very initially, at the initial stage.
The photograph that it was partly demolished. And 13th April, I have submitted.
What
my
does
photograph.
partly demolish mean?
Structure was
15th of-
demolished as instructed by the client, and of which we have also given the photographs. Your lordship will find out that
Have you seen the photographs given by the?
whole roof hole, only one portion hole. That is the demolished.
My lord, I have some photographs of 15th of May. Your lordship will kindly have a look.
No, even the photographs by the enemy properties is here. The
Yes,
building is there.
yes, that is what I'm saying. I'm supporting her contention. My lord, we have photographs from where it will reveal the G+5 building, and it's a date is given here, 15th of May 2020, after your lordship's order.
Same here. The date is given.
Grateful, my lord. I'm deeply aware.
It was similar.
Get it demolished.
I know.
No sanction plan.
Please come.
Nothing, not even a scrap of paper has come before them.
A report has been forwarded by the sub-assistant engineer within bracket civil. Assistant engineer civil. Should I direct your officer to come? Let them come. It is found. This is the order. This is the order which was passed on the 21st of April. And the court was shocked to see as to how the police and the officers of the corporation were in good rapport, and that is the reason the building is still there. So let the officer come. Ki bollam? And executive engineer within bracket civil building, Borough 4 and 5 on 3rd May 2023. Stop. not stop, mentioning that the demolition program was carried out on 17th January 2023 and 16th February 2023 with the assistance of the local police station, and considerable amount of the aforesaid structure was demolished. Stop. A joint inspection was also held on 13th April 2023. Stop. At the time of inspection, it was revealed that all constructional work is lying suspended. Stop. Next. Upon perusal of the report and the photographs annexed to the report, the court is not convinced with the submission of the engineers of the corporation that the unauthorized portion has been substantially demolished. Stop. Next. In view of the above, the executive engineer within bracket civil/building Borough 4 and 5 is directed to remain personally present in court on 19th May 2023.
I'm not available on 19th May because I'll be out of state.
18th.
না না আমি থাকবো না আমি কালকে আজকেই বেরিয়ে
19th May 2023, when the matter will appear in the list marked for orders. Keep somebody here.
I'm grateful.
My junior will be there.
My lord, the entire premises is without sanction. The entire G+5. Grateful, Lord.
Please communicate this order immediately.
Yes, Lord. I'm grateful.
Add one more line. The officer in charge of the Amma Street Police Station is also directed to remain personally present in court at 10:30 a.m. on 19th May.
Lordship, kindly come to the order dated 17th April 23.
I am for the municipality.
I beg to appear for the private respondent.
Which municipality?
This is Rampurat municipality in the district of Birbhum.
As per direction by your lordship, I have submitted report, my lord.
Without affidavit.
রামপুরহাট municipality. কি বলছি
আমাকে রিপোর্টে কপি দিন
না না সবে কনস্ট্রাকশন শুরু হয়েছে কিছুই আনা
Your Lord.
এর কপি দিন একটা
Allegation is that the private respondent number 11 is a promoter and is constructing G+5 building without any sanction.
Yes.
You
Allegation.
are there for the respondent number 11?
Yes, yes. My lord, I have sanction plan.
Very well. I'll hear you.
Now, Lordship, kindly come to the report filed by the concerned state authorities. Kindly come, it's a very important report.
Yes.
State authorities, kindly come, third paragraph. It is to be stated that both the respondent number 11 and 12 are asked to produce the sanction plan and permission copy of the Rampurat municipality for constructing multi-storied building flat over the above mentioned plot. But they could not produce any sanction plan and permission copy of Rampurat municipality for construction of multi-storied building flat. Clear from the state reports that they could
Let
not
us see whether he has a plan or not.
It's a sanction plan.
Yes. When was it sanctioned?
Lord, it was sanctioned in 2023. It was sanctioned, but the March 10, 2023.
Very well. And what is the height?
My lord, it is the sanction has been given till T+3.
Is the construction made till now?
My lord, construction has just started.
Oh, you've not raised.
No, after the sanction plan, I just started excavation. Now your lordship would kindly take the writ petition. They have asserted that the construction is already over at paragraph 12. And when I submitted the sanction plan on the earlier occasion, my learned senior friend said that I made out a new case that I do not have conversion. My lord, I have a conversion.
Kindly seek the date of the conversion.
My lord, kindly see.
What is the date?
2022.
Yeah.
After conversion, then I have to apply for sanction plan. 11th of November 2022.
Please come.
Lordship, kindly come page 24.
What is the next point?
Kindly come
No
page.
plan?
No. This is 23 record of rights, so shows that it is an agricultural land.
Will that be correct? Or will the document which the petitioner has obtaining sanction that be correct? Will the petitioner be responsible for updating the records by the government? Try to understand, make logical submission.
This document it has been shown to the petitioner. But Lordship, this is the record of right.
The private respondent will be obliged to show a document to you, obtain permission from you, and then go for raising construction. Is this a law?
No.
Please make logical
Lordship, kindly appreciate. Look, this is the regarding conversion. I'm saying raising conversion. Kindly come page 24. It's now still is an agricultural land.
Complaints of illegal and unauthorized construction being raised by the private respondent without obtaining any sanction from the municipality and without converting the classification of the land in question. Stop. According to the petitioner, the land where the construction is being made is still recorded as agricultural land. Stop. And the petitioner where has it been averred that the 5-story has been constructed?
Paragraph 13.
13.
Page 12. Petitioner states that private respondent erected the flats illegally, without giving any open space.
Open space.
And the petitioner has constructed, and the private respondent has constructed G+5-story building without obtaining a proper sanction plan. The aforesaid contention of the petitioner is denied by the private respondent. Stop. A photocopy of the sanction plan issued in favor of the private respondent has been produced in court. Stop. The order of conversion by the Office of the Blockland and Land Reforms Officer, Rampurhat 1, Birbhum, has also been produced before this court.
Also, kindly consider the plot number.
The learned advocate representing the municipality. It has been submitted that after obtaining the sanction plan, only the excavation work has been done. Stop. No construction has been started as yet. Paragraph: learned advocate for the municipality has obtained instruction from the chairman in April 2023, mentioning that the municipality sanctioned building plan for raising residential G+3-storied building in favor of the private respondent in March 2023. At present, only the basement work has been made. Stop. Next. From the submissions made on behalf of all the parties and upon perusal of the materials on record, it appears that the allegation raised by the petitioner is absolutely false. The all incorrect submissions have been made in the writ petition. Stop. The private respondent does have a sanction plan for raising construction and also has the necessary order for conversion of the agricultural plot of land to Bastu land where construction is permissible. Stop. In view of the above, no relief can be granted to the petitioner in the instant writ petition. The same stands dismissed with costs assessed at rupees. How much? 10,000. ₹5,000. The cost.
Only one thing, Lordship, the
cost shall be deposited in the office of the High Court Legal Services Authority by 19th May 2023. Stop. The matter stands, though the matter has already been dismissed, but the same will appear in the list on 12th June 2023, only for ascertaining whether cost has been deposited or not.
what's the cost, Lordship?
No. When you make allegation, you should
Lordship,
bear
the
some
police has supported
responsibility.
my allegation. I don't know, Lordship, this report has not been given to me, but Lordship, the police has supported my allegation. Kindly see the report of the police.
I have seen the report of the police. The petitioner, the private respondent, is not obliged to produce the document before the police. Who is the police to see whether he has a sanction plan or not? Is the police the appropriate authority? How much you paid to the police?
So police has also right
How
to.
much have you paid to the police?
No, I don't know. Lordship,
You don't know. Your client knows. Let him pay over here the cost. Otherwise, see what is going to happen to him. 5,000 rupees, let him
Lordship,
pay.
let the report of the concerned municipality be handed over to me, because at least
Whatever is there in the report is there in the order. You cannot say a single word which is there in the report but not in the order. So you will not be able, nobody will be able to say that anything is there in the report but not in the order. The report is open.
the Lordship, kindly the date may be extended,
Yes.
because he
Why?
is starting in Birbhum. Lordship, I have to inform him. Lordship, kindly after vacation, kindly fix a date.
I am fixing a date. It will appear in the list on the 12th of June. But
12th.
make payment by this Friday. Call the next matter, please.
Sure. Yes. I am for the statement.
Yes, petitioner.
29. My lord, I appear for the petitioner. My lord, before opening my case, my lord, I humbly submit before your lordship that the writ petition was not happily drafted. My learned friend has prepared, my lord. The crux of the writ petition is, my lord, the building in question has not been constructed following the open space norms, my lord. That is my humble submission. And my lord, your lordship,
Is the private respondent there?
last occasion, your lordship directed to serve afresh, and it has been.
Has it been received?
My lord, item delivery is confirmed. And this was the, my lord, two affidavit of services are there, my lord. I am.
A report is to be filed by the corporation. What does your
Or I have filed the exception in that case. If he is submitting that the entire building has been demolished, my lord, it has been recorded and I'll file the exception.
Was done. But I can show the even the right now I have got a WhatsApp message, but again I asked that whether any further unauthorized construction took place. You'll also kindly excuse me, my lord, handing over this.
Building টা আছে তো ওখানে?
The slab of the second floor
Yes.
has been damaged and demolished. What about the rest?
Yes, whatever unauthorized was there, but it has been demolished.
No, open space norms, my lord, regarding the ground floor.
No, no, I won't see your phone. Stop work notice. Pollution.
Submitting that building has been demolished.
Second floor. After defining sanctions.
জয়েন্ট ইন্সপেকশন হয়ে যেত তারপর তো পিলার ভেঙে দিয়ে
And further, a joint inspection was also there. On 13th of April 2020, recorded that there was no work at top floor at about 3:45 PM. The work was completed and all engineers and trades returned to work and PS.
My lord, your lordship may kindly have a look, my lord, that is my readings, my lord, that is at my lord. Paragraph,
What type of drafting is
my
this?
lord, it is very, I pray unqualified apology for this, my lord. Friend. It is, I'm not satisfied with it. It cannot be in that manner. Prayer is, I have seen, my lord, cannot be. Cannot be, my lord.
Police report. Let me see. What does the police
But my
report
lord,
say?
simply, issue is very short, my lord, that the open space norms have been violated, my lord, in respect of the ground for till the building is persisting there, my lord, in violation of the same.
You should take care of these type of drafting. What is this?
My lord, my lord, kindly ignore.
Ignore. How much can the court ignore?
Yes,
The court hardly opens the briefs because once it is opened, the matter will go. It is only relying upon the submission
No
of the
doubt.
learned counsel that the matters are being taken up. At least the prayers should be all right.
কি করবে? Afresh file করবে? Or in that case, my lord, subject to lordship's sanction, my lord,
What? You will withdraw?
liberty may be granted and fresh.
Where you will do
to
that?
file afresh. I think it should be better. Otherwise,
Learned advocate
without
representing the
taking troubles, my
petitioner
lord.
seeks leave to withdraw the writ petition as there are certain incurable defects in the same. Stop. Liberty has been sought to file afresh
Self-same
on the
cause of action.
self-same cause of action
Grateful to lordship.
upon proper and better particulars.
Grateful.
Stop. Next. Liberty sought for. Now, leave sought for is allowed. Liberty granted to the petitioner to file fresh writ petition upon on the self-same cause of action upon proper and better particulars.
My lord. Grateful.
Report filed by the executive engineer within brackets civil building department dated 13th March 2023 in connection with the allegedly in connection with the self-same premises in WPA number 7919 of 2022 and the report filed by the inspector by the officer in charge Wadganj police station signed on 21st February 2023 be retained with the records.
Lord, subject to lordship's sanction, may I have a copy of the reports, my lord?
I have not seen it. You do
My lord.
whatever
My lord.
your client advises you to do.
Grateful to lordship, grateful.
Okay, sir. Everyone was circulated, the order was circulated, report was circulated. A report দেয়া হয়েছিল আমাদের আগের বার। হ্যাঁ,
হয়নি স্যার।
মিথ্যে কথা। Sorry to say, মিথ্যে কথা। ওতে আমি নিজে দিয়েছি তো।
আচ্ছা ঠিক আছে, থ্যাংক ইউ।
My lord, I am appealing for the petitioner. My lord, by order dated 17th April 2023, my lord has asked the my lord respondent corporation to file and report by way of an affidavit. Where the issue was, my lord has passed an order in the writ petition earlier occasion to my lord, to take steps for the illegal construction, my lord, and pass a recent order. My lord, they pass an order, my lord, and in the order, my lord, they found out, my lord, 2 floors, 4th and 5th floor, my lord, are completely illegal without any plan. And my lord, rest there are deviations. If my lord kindly takes up that order, my lord, for the moment, my lord. Kindly takes up page 78.
Is there any private respondent?
Yes. No, for the timing in this writ petition, no. Earlier occasion, yes, there was. Because
Here
now,
there is
no.
nobody.
Now, my lord,
78.
78.
Yes.
My lord will find in page 78 the description of my lord deviations, infringed. But thereafter, kindly turns over, my lord, the order. There is a part A, demolition of 4th and 5th floor, all projections are beyond sanction within 15 days from the date of communication of the order as supervision of such and such appointed by person responsible, failing which demolition action may be taken by the department and
corporation was
cost.
directed to file a report. Let me see.
But the report doesn't really answer that queries of my lord. But my lord, his appeal was preferred by the person responsible. They either obtain a certified copy of the order or communicate. My lord has recorded in the order dated 17th April that
Yes, whether the order was at all approved by the higher authority, whether the same was communicated to all the parties.
and had not the approval of the mayor been there, the demolition would not have been initiated. There has been part demolition, the occupied portions could not be demolished as per.
Is there any requirement of obtaining a fresh approval
Yes,
from
yes,
the mayor
that
and
is
council?
there in the amended building. I had shown it to my lord on one occasion. It is there.
You did.
It is there.
There is a requirement of
Yes.
obtaining.
Either proceed with the demolition or challenge the order. Corporation itself.
That is different. Challenging, once it is challenging, it's a different course of
Yes.
action.
But there is now a requirement.
There is now a
Yes.
requirement.
But since my lord, demolition was initiated, part demolition took place, an appeal was preferred,
To that, my lord, I took instructions, my lord, I have photographs. My lord, the 2 floors which was found absolutely illegal. My lord, this is a photograph in the month of April. My lord, this has come up in November 2022. My lord, the photograph speaks otherwise. There is not even a partial demolition. My lord, I can put that on affidavit as well.
1 minute, Department Register Stop Work Notice 2020. And the matter was processed of the order of demolition to demolish the rest of the
the vacant portion of the building was demolished.
Where is the description of the vacant portion?
That obviously the report does not have, my lord, but I can give photographs.
No, your photographs will not do. The entire building, which portion is vacant, which portion has been demolished, nothing can be identified from there.
But the occupied portions, my lord, have to be vacated by the police. That is always the problem. Here also, this is the problem.
Department is also sent to the fact remains that the unauthorized portion is still there. Are you aware as to what happened in the appeal? No.
My lord has recorded that stay was not granted. In the 17th April order, my lord has recorded.
Where from did the court get to know stay was not granted?
My lord came to know of this, my lord, on page 79.
There is an order.
Yes, my lord, kindly sees the part B. After part B, the second paragraph, the last line of that second paragraph. In the meantime, PR filed a petition before the Municipal Building Tribunal. BT cell deputy manager informed that the next, in the meantime, PR filed petition before such and such. Date of hearing before the MBT is fixed on 24/11/2022, but stay appeal has been rejected.
All right.
And one thing, my lord.
Yes.
But I submit that the order has been substantially more than compliant with.
How?
Because kindly see page 71. Right. The last paragraph there.
Yes.
In view of the above, the instant writ petition is disposed of by directing the Kolkata Municipal Corporation to take necessary steps for completion of the proceeding initiated by them in response to the complaint lodged by the petitioner.
Where is
That
the
has been done.
completion?
The SOB's order, that is the culmination of the proceeding. Now, a different proceeding has replaced that, the appeal before the tribunal. But our order, my lord's order, good or bad or whatever.
No, thing is, he is praying for implementation of the same.
That is different.
My lord, initially I came up in contempt. My lord, this contempt order, my lord, will find at page 76. There, my lord, held, my lord, an order has been
Yes,
passed.
praying
In
for
this
implementation.
second writ
Now I'm praying
petition,
for implementation
now
of this.
police authorities are the parties. My lord will direct the police to have the occupied
It is
portion.
different, but fact
Yeah,
remains that
I was under the
the
impression that it is a contempt. I stand corrected.
today is not Thursday. You are moving fast.
That is a little tense now. I'm more relaxed.
Now, my lord,
The
only
di-
one thing may I add, my lord, though contempt has been disposed of, but my lord, if my lord sees the order at page 79, this has two parts. One is part A, complete demolition. And after that, they again say, my lord, for the other portions being which is infringed, my lord, there will be a hearing.
What is the position before the tribunal?
My lord, we have not been served with copy. I rely upon page 79, which is their order, which says
then that is
stay has
long
been
back.
rejected.
Long
Stay has
back.
been nothing. There is no stay. There is no stay.
If the petitioner
Otherwise,
wants the
corporation-
building demolished, he might as well get the necessary orders from the tribunal.
No, that can't.
Your client will not do anything. Everybody will roam around everywhere.
Police will
From pillar
demolish,
to post,
police will
go
vacate,
there.
they'll get the updated
Yes.
orders. Right and left, my lord, we need support.
দীপক
The
মুখার্জি আর কি
আবার দীপক মুখার্জি কোথায় গেল?
তুমিই তো ছিলে ভাঙিয়েছো পুলিশ দিয়ে এই দিয়ে
দীপক মুখার্জি আমার দাদা।
ও
the report filed by the engineers of the Kolkata Municipal Corporation dated 15th May 2023 mentions that a demolition gang along with the police personnel of Entally Police Station went to the subject premises at B by 48 by H by 27, Pottery Road, ward number 56 Borough 7 of the Kolkata Municipal Corporation on 15th June 2022 and found that the building is almost fully occupied. Stop. The vacant portion of the building was demolished on the said date. Stop.
But the police authorities have not been implicated here. State has not a party.
I can implement local
For the
PSK
purpose
implement
of
করে দিচ্ছি। কি আছে?
implementing the order of demolition, the engineers of the corporation requires the help of the police for vacating the portions constructed unauthorizedly.
একটাও পাওয়ার আছে পুলিশ দ্বারা
Stop.
একটাও পাওয়ার আছে ওটার তো
পুলিশকে বলা হয়।
পাওয়ার আছে
Instruction mentions that the department has sent a reminder to the officer in charge, Entally Police Station, on 13th of May 2023. Stop. Next. It appears from the submission made on behalf of the parties that the order of demolition passed by the special officer building was carried in appeal before the municipal building tribunal, where the application for stay stood rejected. Stop. The corporation is bound to implement the order of demolition. Stop. Next. The
Enough. Get enough.
officer in charge of the jurisdictional police station is directed to render all necessary help and assistance to the men and agents of the Kolkata Municipal Corporation
Excitement.
at the time of effecting the order of demolition, if sought for. Stop. Steps shall be taken to conclude the demolition proceeding at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. Let the matter appear in the list once again on 12th of September 2023, marked for orders for recording compliance.
One thing, first the building be vacated. Then we can send our personnel.
The officer in charge of Entally Police Station shall take steps to vacate the portions which were constructed unauthorizedly, and the men and agents of the corporation shall remain there on the spot at the time of vacating, so that the demolition can be conducted simultaneously.
And the officer in charge should be added as a party.
That leave may be granted. I will add herein now.
Leave granted to the officer in charge, a leave granted to the learned advocate on record of the petitioner to implead the officer in charge, Entally Police Station, as party respondent in the instant writ petition,
The presence of
and a copy of the writ petition be served upon the added respondent and also in the office of the learned government pleader, High Court, Calcutta.
the presence of the corporation officers during the vacating process
Yes.
may put their life in peril.
So, carry bodyguards.
The petitioner's lawyer is a brave young man, my lord.
You too. Yes, the Passover matter.
Item 9. Lordship, the division bench has upheld the order that was passed by your lordship.
Which order?
The earlier order of
Which is the earlier order?
And my lord, on the last occasion, a little bit modification has been done, my lord.
Modified regarding the presence of the developer, that has not been state. It has only said that the works of demolition to be carried out to the corporation at the cost of the developer. Petitioner, that the person who was carrying it to be present.
And
the materials, again, you lost my lord, as you know, monitoring the entire issue regarding the demolition, that may be done. That may be done.
That will continue.
The court is not monitoring anything. It is for you to monitor. Why will the court take up this responsibility?
Where people are taking action taken and university is looking at that, then how much progress has been done.
Yes. So when will you demolish?
Well, the subsequent date, I don't know when it has been fixed. Well, I ascertain.
And my lord, your lordship was pleased to make the personal appearance of respondent number 11. Till now, he is not present in the.
But then that has been modified by the court.
No, that has not been modified. That was expressly stated by the division bench.
This has not been modified.
This has not been modified.
No.
Appearance has not been stayed.
Appearance has not been stayed. Appearance of the respondent number 11, they had stated before the honorable division bench that division rejected the same. And also ordered that today he should be present. But till now, he is not before this honorable court.
Please come.
And my lord, on the last occasion, the report that was placed.
He is present.
Where is he?
Court number sitting outside.
Why sitting outside?
2 minutes. Only 2 minutes. Give it.
Yes, sir. And my lord, on the last occasion, the report that was placed by the corporation, my lord, I had placed a picture, a photograph with the date and the time, my lord. And that depicts that there's this one, lordship. And it itself depicts that the whole building is standing as it is. The pillars, it is not a considerable portion has been demolished, is not to be
The entire building is unauthorized.
Entire building.
My lord, may I?
Entire G+5 building is completely unauthorized. G+4 building, sorry. G+4 building entirely unauthorized. And this is the demolition progress, my lord.
My lord, I appear for the respondent number 11. My lord has directed me to my lord, demolish.
My
The
lord,
division bench said it will be demolished by the
Yes, yes, yes.
corporation. So whatever the construction, I do not stand in the way. Even a brick, if it is found unauthorized, let it be also demolished.
From the very
But
foundation. it is
only my
illegal,
point
my
is,
lord.
my lord, why me? Because it's a 408 proceeding. It is for the corporation to take charge. And that was a direction previously by Minor Justice Doctor's division bench, followed by 2 previous order of the coordinate bench, that the corporation will continue the same and will not stop until its fullest completion. That is why, my lord, we only, my lord, humbly beseech, my lord, that let the corporation be, my lord, directed, my lord, to execute the order passed by the previous 2 coordinate benches, affirmed by the honorable division bench, than to complete the same until it is being completed.
My lord, the last order.
I do not say, my lord, whether it's a pillar or something, otherwise construction is there, whatever be found unauthorized.
My lord, in the last occasion, the report that was placed by the corporation, there is a considerable part has been demolished, only the pillars are remaining. And that was also been supported by the respondent number 11. My lord, I had placed the photographs before your lordship, and this is the another photograph.
Is the building? Is this the building? Your client is there? Is
My
this the
lord,
building?
yes, client. But so far as my lord directs that, the client is here.
Client is here. Where is he? What is his name?
My lord, Shambhu Das.
And this is what he has constructed. And how has he constructed without a sanction plan? Inquire from him. Don't scratch your head. Inquire from him. How did he raise construction without a sanction plan?
My lord, that was a Thika property, the construction
What
was.
is whether
My
it
lord,
is
of
whether
course,
it
of
is
course.
his own, whether
Of
it
course.
is maternal
Of course.
property.
Now,
that
my lord,
is
what
not
my instruction is, my lord, kindly appreciate this.
And now when you raise construction and the demolition is to be made, it is to be made by the corporation. Certainly, pay the cost.
That has been directed.
On phase melody basis, the demolisation program with the progress of the work, bills to be raised, they have to pay.
My lord, so far as the cost are concerned, lordship, I kindly appreciate, my lord, it is the person responsible. My lord, I would not take more than 1 minute, sir, a second. My lord, they have any,
I am not here to hear you even for a second.
my lord, so
If your
far as,
client has done something illegally,
yeah, my lord, so far as the illegal part is concerned, 401A proceeding, the corporation has initiated and municipal magistrate has exonerated me from any charge. Municipal magistrate has said, upon trial, my lord, he has exonerated me and I am directed to be acquitted as I am not guilty with regard to the unauthorized construction is there.
Whereas the considerable part has not been demolished, my lord.
the unauthorized building is standing tall, still date. Stop. The photograph of the building as it stands today has been produced in court. Stop. The same belies the submission of the, not submission, but the statement of the executive engineer, civil building department, which mentions that considerable portion of the roof and the walls of the third, second, first and the ground floor of the premises was demolished. And at present, all the floors have become unfit for human living. Stop. Next. It appears that the executive engineer, without proper inspection of the
My lord,
subject structure, has forwarded this report. Stop. The conduct of the executive engineer is highly deprecated.
yes.
Stop. The executive engineer within bracket civil is directed to remain, civil borough 3 is directed to remain personally present in court on 19th May 2023 at 10:30 a.m. Stop. The 10:30 a.m. with the assessment of cost that is required, that will be required for demolition of the entire G+4 storage structure. List on 19th.
My lord, kindly record that Mr. Shambhu Das is present and he is being discharged, my lord.
Who said he is being discharged?
my lord, subject to correction, my lord. It is
No,
my prayer,
don't try to put in words.
my lord, it's my
A
prayer.
very bad practice. The
My lord,
court is not appreciating
My
it
lord,
at
my
all.
lord, it is my prayer. My lord, I tender apology, my lord.
It's not a prayer.
My lord, it is my,
prayer.
my lord, it's my apology, lordship. Kindly do not take me amiss.
God. The respondent number 11 is personally present in court. Stop. He is directed to remain personally present on the 19th.